Good evening. I'd like to call the meeting to order and welcome you to the regular meeting of the Milwaukee Planning Commission. Agendas and additional copies of staff reports are available on the table in the hall. If you have not picked up an agenda, please do so. It contains important information about the process. If you wish to be included in the mailing list for a decision, please add your name and contact information to the sign-up list located on the table in the hallway. If you wish to testify, please also fill out a yellow comment card. We will follow the basic format listed on the back of the agenda. It includes all of the hearing procedure steps. We may vary from the process based on the specific circumstances of each hearing. We do not have any minutes. That's next on the agenda, so move along. Informational items. Are there informational items from staff?
I wanted to, I don't know how many of you may have responded, but you were invited to a field trip in a couple of weeks related during the middle of the day, so I understand that if you can't go, but there was a field trip to visit some cottage cluster sites in Portland. So if you hadn't responded yet, or if you don't know, that's great, but I'd hope that you could respond and let us know if you're coming. That will also help us know whether or not we need to advertise it as a meeting, depending on how many of you are there.
Yep. Okay. Thanks. Audience participation. This is an opportunity to comment on items not on tonight's agenda. If you wish to comment on an item that is on the agenda, there will be a time for comments after the presentation. Does anyone wish to comment on an item that is not on tonight's agenda? Okay. All right. The next item is a public hearing on Washington Street vacation rental. So type 3, right? Yeah, okay. The public hearing on Washington Street vacation rental is called to order. The purpose of this hearing is to consider application number CU-2018-004. The purpose of the application is to request a conditional use on property located at 3316 Southeast Washington Street. The applicant has the burden of proving that the application is consistent with all of the City of Milwaukee's zoning and subdivision ordinance, comprehensive plan, and any applicable municipal code provision. The applicant has the burden of proving that the proposal conforms with all of the city's applicable criteria. I will now ask staff to cite the zoning ordinance sections where the criteria can be found.
Subsection 19.301, low-density residential zones, subsection 19.905, conditional uses, and subsection 19.1006, type 3 review.
All testimony and evidence must be directed toward the applicable substantive criteria. Failure to address a criterion or raise an issue with sufficient detail to allow Planning Commission an adequate opportunity to respond to each issue precludes appeal to the City Council based on that issue. Failure to raise constitutional or other issues related to proposed conditions of approval with sufficient detail to allow response precludes an action for damages in circuit court. Any party with standing may appeal the decision of the Planning Commission to the City Council. Persons with standing are those who submit written comments or testify in person or sign the Planning Commission attendance sign-up sheet in the hallway. I will recognize those persons who have completed the testimony cards and given them to me or Vera. When you come to the podium, please state your name and address for the record so they may be entered into the minutes. If you are here to testify, please remember to confine your remarks to the application and the relevant criteria and to avoid repetition and irrelevant information. If additional documents or evidence are provided by any party, the commission may, if requested, allow a continuance or leave the record open to allow the parties a reasonable opportunity to respond. Any such continuance or extension shall be subject to the limitations of the 120-day rule unless the continuance or extension is requested or agreed to by the applicant. All right. Conflict of interest and site visits. Does any member of the Planning Commission wish to abstain from this hearing?
No.
No. Does any member of the Planning Commission wish to declare an actual or potential conflict of interest? No. Does any member of the Planning Commission wish to report on any ex parte contacts?
No.
Yes.
I visited the site.
But that's not.
It's okay if you visited the site. It's if you had conversations with
Got it.
someone while you were there. Yep. Okay. Does anyone have any rebuttal to the ex parte context declared by the commissioners? Will any commissioner who has visited the site prior to this hearing please raise their hand? Did any of those commissioners who visited the site speak to anyone at the site or note anything different from what is indicated in the staff report for this application?
No.
No. Does any member of the audience wish to challenge the participation of any member of the Planning Commission? Okay. Does any member of the audience wish to challenge the jurisdiction of the Planning Commission to hear this matter? All right, well then let's proceed to the staff report presentation.
Good evening, Vera Coles, Associate Planner, to present the staff report for this project.
Make sure you speak right into the mic.
Okay. The site in question, 3316 Southeast Washington Street, is indicated here in red on the map. The site contains a single-family home, as well as an accessory structure, a shed. There's an attached deck and an attached garage, providing private off-street parking for 2 parked cars on the site. The site itself is 5,470 square feet. The site is zoned R5. The surrounding area consists of residential single-family homes that are all zoned the same as the site, again, R5. The site is separated from Highway 224 by a planted area to the north, and across Highway 224 from the site is Milwaukee Marketplace. The proposal by the applicant is to allow the home to be used as a vacation rental. And just for the edification of folks in the audience and at home, a short-term rental is a housing unit, an ADU, or rooms within a house that are rented out for a short-term basis. It's accessory to the primary residence, and it is allowed as a home occupation where the residence has to be occupied by the owner or operated for a minimum of 270 days a year. It's kind of your classic Airbnb kind of situation. Short-term rentals, again, are permitted as home occupations. The difference in this case is that this is proposed as a vacation rental, which is a housing unit that is rented out to a single party for a period of less than 30 days where there are no primary occupants on the property, so the property owner does not live in the home. Typically, a vacation rental's primary use is more commercial in nature because it isn't being used as a single-family home by the owner. Because they function a bit differently in a neighborhood, the code permits them as a conditional use in residential zones. That's why the conditional use is being sought in this case. The approval criteria for the conditional use are that any identified impacts will be mitigated to the extent practicable, and that the proposed use will not have any unmitigated nuisance impacts on surrounding properties. So the key issue is making sure that this application does address those approval criteria. The property has been inspected and has been approved as a short-term rental. That was at the time when it was understood that it was going to be a short-term rental, so it's actually kind of already gone through that building inspection process as a rental property. It also has a current business registration as well. But the property does not live, or the property owner does not live on site and would like to be able to use the property as a vacation rental. The application materials talk about the proposed vacation rental, and staff agrees that it will not result in any change to any physical characteristics of the property. There aren't any major changes being proposed to the property. The residential use of the property won't change, but there will be folks in and out of the property. Minimal impact on nearby uses since the property has off-street parking that can accommodate 2 cars, and the home and the use of the home or the rules of the vacation rental prohibit any smoking or vaping or anything like that, both inside and outside, and there are quiet hours from 10 p.m. to 6 a.m. on the property. The applicant lives approximately 2 miles away from the site, so can readily respond to any issues should something arise by the folks that are staying at the house. During the public hearings for similar conditional uses back in 2017 and then again in 2018, Planning Commission included a condition to require the applicant for a vacation rental to provide notification to property owners within a 250-foot radius from the site. Notification requires the inclusion of contact information for property owners or a property contact for folks, the NDA contact information, City of Milwaukee Police non-emergency line, and the applicant's non-smoking, quiet hours, and similar kind of policy. Staff has provided a similar requirement for properties as a condition of use, condition of approval for this property, but we have changed it to the 300-foot notification so that it's consistent with what the public notice was for the hearing. Staff believes that the applicant has provided the information that shows that they can meet the approval criteria for the conditional use, particularly any impact that might occur with the surrounding neighbors, and certainly through the conditions of approval. And of note, at the last City Council meeting on February 5th, there was a code amendment that was included that codified these conditions of approval into the conditional use description for vacation rentals, and that was adopted by City Council. So we don't need to keep including them as conditions of approval. It's been codified. Staff did not receive any comments. One phone call was received, and just clarifying that it was a vacation rental and just kind of what that meant in the code, but no comments. It was just a clarification question. Staff's recommendation is to approve the conditional use for the property, and again, this would result in the ability to use the home as a vacation rental. Staff also recommends adopting the attached findings and the conditions of approval. Per usual, the Planning Commission has some options tonight for the decision. You could vote to approve the application with the findings and conditions of approval. You could approve the application and modify the findings and conditions of approval. You could deny the application. We would need to provide findings to deny the application, or you could continue the hearing. The 120-day clock on this application runs out on April 17th. The applicant, the property owner, is here, so she'll be able to answer any questions that you might have specific to the property as well. But I'm happy to answer any questions from the code perspective, if you have any.
Any questions for Vera? Anybody?
No questions.
I have a question.
Yeah.
So the home occupancy standards apply only to a short-term rental.
Correct.
Okay,
That's
right, 'cause-
considered a home occupation.
Okay.
Because it's accessory to the primary use of the property as a
Right.
single-family home.
Okay.
Yep.
But in the staff report, there's a lot of reference to the comp plan and talking about home occupations within the staff report. So for example, on page 9, number 6, it's saying the proposed use is consistent with applicable comprehensive plans, policies, and proposed use. And so it's just a little bit confusing in there because it's referenced, the
I
home
see.
occupations
Okay.
is referenced within there, but this isn't really. So when I looked at the code, 19.507.5, which is the home occupancy
Right.
standards, are not relevant to this
Right.
particular application.
I can take those references out if it's
Okay.
confusing the findings. No, that's a good catch. Thank you.
Do you know if there are any current renters there? This has been a short-term rental. It's been in that status for some time, Vera, as you understand it.
It was originally permitted as such back in October, and then through clarification with the property owner, she applied for the vacation rental, so
Okay.
it's been a couple of months that
Okay.
that it's been used that way, yes. Yep.
Okay. Anyone else? Questions for Vera? No? Okay, thank you.
Thank you.
Would the applicant like to come up and say a few words? That'd be great. If you could have a seat and then state your name and address for the record and make sure you pull the microphone down.
Okay,
That'd be
sure.
great. Thanks.
Thank you. Thank you, first of all, to all of you. And my name is Pilar Pinel. I live at 4787 Southeast Concord Road, Milwaukee, 97267. And the property that we have is, that we are asking for a vacation rental, is the one that we purchased to help pay my son's tuition at school. So I don't know what else you would like to know tonight.
Yeah, well, thank you for coming. Does anyone have any questions
No?
for the applicant? No?
No.
It's pretty clear and straightforward. So
good.
we thank you for being here. I think at that, we will move along unless you have additional comments for us.
No, I
Okay.
just want to say thank you very much.
Okay.
Thank you.
All right. Do we have anyone in the audience related to this application? Is everyone in the audience for the next hearing? Okay. All right. So we don't have any testimony. It doesn't appear that we have any questions from any planning commissioners. No? Okay. So then let's go ahead and close the public testimony portion. The public testimony portion of this hearing on file CU-2018-004 is now closed. No further testimony can be taken unless the public hearing is reopened. So, are you guys ready for discussion?
Ready?
Okay. Anyone?
I'll go first. Do you want to go?
Oh, yeah, go ahead.
Mine will be very dull and quick, which is to say we've had several of these. This is non-controversial, and I'm inclined to approve.
Yeah, it meets all the criteria. It's really straightforward. I have nothing, I have no concerns about this based on the conditions of approval, so I think we're good.
Okay.
I'm in accordance with Commissioner Burns and Commissioner Edge.
This side over here?
I'm also in agreement with the other commissioners.
I think that the certain fact that this has been acting as a vacation rental and there is nobody here to testify that says that it should not continue because of noise and complaints speaks loudly to it, so their policy seems to be working. And we just attach those conditions of approval, and sounds like a good idea.
Yeah, I have no concerns over this, and I think that we should move upon the citizen's request.
All right, well then I will entertain a motion.
I would like to make a motion to approve application CU 2018-004 and adopt the recommended findings and conditions of approval found in attachments 1 and 2.
I'll second that.
All right, motion and seconded. All those in favor, say aye.
Aye.
Opposed? All right, motion passes. If anyone wishes to appeal this decision to City Council, you must make applications stating the grounds for your appeal within 15 days of the mailing notice of the decision. Please see planning staff for details. All right, thank you very much for coming. Yeah, you can, welcome to stay if you want. Okay, moving right along.
Thanks, Vera.
Thank you. Now let me, okay, we got. Oh, okay. Great. Thank you for pointing that out. Yes. This is the applicant, right? Okay. Okay. The public hearing on appeal number AP-2019-001 is called to order. The purpose of this hearing is to consider an appeal filed by Daniel Barella challenging number MLP-2018-001, a minor partition of property at 10244 Southeast 43rd Avenue. The appeal process requires that the commission conduct an unrestricted de novo hearing, which allows for the presentation of new evidence, testimony, and arguments by any party. The applicable standard of review is set forth in zoning ordinance subsection 19.1010.3. types of appeal hearings. A successful appeal requires that the commission determine that the initial decision has findings and/or conditions that are in error as a matter of fact or law. The original decision was based on applicable standards and criteria of the Milwaukee Municipal Code. I now ask staff to cite the code sections where the standards and criteria can be found.
Primary section is 19.1010 for appeals, and then these following sections relate to the original decision from our Land Division title, Chapter 17.12, Application Procedure and Approval Criteria, Chapter 17.16, Application Requirements and Procedures, Chapter 17.20, Preliminary Plat, Chapter 17.28, Design Standards, Chapter 17.32, Improvements, and then from the zoning code, section 19.301, low-density residential zones, including the R7 zone, chapter 19.700, public facility improvements, chapter 12.16, access management, chapter 19.1200, solar access protection, and section 19.1005, type 2 review.
All testimony and evidence must be directed toward the applicable substantive criteria. Failure to address a criterion or raise an issue with sufficient detail to allow the Planning Commission an adequate opportunity to respond to each issue precludes further appeal based on that issue. Failure to raise constitutional or other issues with sufficient detail to allow a response precludes an action for damages in circuit court. This decision will be the City of Milwaukee's final local decision on land use file number MLP 2018-001. The order of business we will follow in conducting this hearing is on the screen here. Discussion of impartiality, site visits, and jurisdiction, staff introduction of the appeal, presentation of the report, correspondence received, the applicant presentation, testimony in support of the applicant, appellant testimony, testimony in support of the appellant, neutral testimony, additional staff comments, appellant's rebuttal and final remarks, and appellant's, I'm sorry, this is, oh, okay, yeah. Applicants, yes, okay, rebuttal and final remarks. Questions from the commission to staff, closure of the public hearing, and then a discussion and decision by the commission. So I will, in the same conduct of the last hearing, I will recognize those persons who have completed the testimony cards and given them to me. When you come to the podium, please state your name and address for the record so they may be entered into the minutes. If you are here to testify, please remember to confine your remarks to the application and the relevant criteria and to avoid repetition and irrelevant information. If additional documents or evidence are provided by any party, the commission may, if requested, allow a continuance or leave the record open to allow the parties a reasonable opportunity to respond. Any such continuance or extension shall be subject to the limitations of the 120-day rule unless the continuance or extension is requested or agreed to by the applicant. All right. Conflict of interest in site visits. Does any member of the Planning Commission wish to abstain from this hearing?
No.
No. Does any member of the Planning Commission wish to declare an actual or potential conflict of interest?
No.
Does any member of the Planning Commission wish to report on any ex parte contacts?
No.
Does anyone have any rebuttal? Oh, sorry, we don't have any ex parte contacts. All right. Will any commissioner who has visited the site prior to this hearing please raise their hand? Did any of those commissioners who visited the site speak to anyone at the site or note anything different from what is indicated in the staff report for this application?
No.
No. Does any member of the audience wish to challenge the participation of any member of the Planning Commission? Does any member of the audience wish to challenge the jurisdiction of the Planning Commission to hear this matter? Let's proceed to the staff report presentation.
Good evening, Chair Travis, Commissioners. Welcome. I'm Brett Calver. I'm an associate planner with the City of Milwaukee, and I worked with the planning director on the original Type 2 decision for this minor land partition, and I'll be walking you through the story and some of the key elements for your consideration of the appeal hearing tonight. So the subject of the original partition is the property at 10244 Southeast 43rd Avenue. The original applicants, who we hear from tonight, Michelle and Tony DeRosa, they approached the city previously about dividing their property, which is about 26,000, almost 27,000 square feet. It's in the R7 zone, so it definitely had potential for redevelopment. Just an aerial shot. And I'll toggle back and forth a little bit. You can see the site is already developed with an existing house. The DeRosas live. There are a number of other accessory structures, the detached garage, kind of an outdoor covered patio and fireplace. You can see some of those represented here with the driveway taking access from 43rd Avenue. So their idea was to keep the existing house and create an additional lot where they could build a new house and have room on both of the parcels for potential future accessory dwelling units, or ADUs, as well. So one of the things that we do when we're approached for land division proposals, we have to kind of zoom up a little bit above the site and look at opportunities for connections. The original idea, a couple of the original ideas from the DeRosas, one idea was to just split the lot down the middle, so kind of having two long, narrow lots, or another idea was more of almost like a flag lot kind of configuration. And in a case where there's no clear opportunity for any kind of street connection, we would explore some of those options a little more thoroughly. In this case, we recognized, and I'll use the pointer here, so here's 43rd, recognized that White Lake Road dead-ended just basically one lot to the east of the subject property. And when we looked more closely at the site, and at that area, since we are looking for the potential to make street connections, or at least some kind of connection for pedestrian or bicycle or vehicular traffic, we recognize that there might be an opportunity to do that. And keeping in mind, one of the things that we find ourselves sometimes looking at the maps of our cities, we notice missed opportunities sometimes. At certain streets, you can see where if a different decision had been made, what ended up being a poorly connected or dead-end kind of neighborhood street might have, if someone had gotten some right-of-way dedication, might have made a connection that would just kind of help circulation in that area. And so we're aware of those kinds of situations and try to be mindful of them. And that's what we noted the potential opportunity here. So when we looked a little more closely at the area, again, the partition property is the one outlined in yellow. And again, here's the end of White Lake Road. We noted that while obviously there is an existing house here, that this lot at 4446 Southeast White Lake Road is large enough in this zone to divide itself. Like if at some point in the future, the owner of this property, a current owner or a future owner, wanted to try to create a second lot, obviously they would need to significantly alter the house or remove it entirely, but that there is the opportunity to split this property and have two lots as well. And so with that in mind, we, directed by our transportation system plan and the code, recognized that we needed to work with the applicant to come up with a plan that would allow us to get a portion of the property that is dividing here, 10244 Southeast 43rd, and have that dedicated to the right-of-way so that we could have the potential in the future for some kind of a connection, whether it ended up being a full street or some kind of pedestrian or bicycle connection. So with that in mind, we worked with the applicant, again, kind of taking into consideration what was on the site, and the applicant came up with a proposal for a second lot behind the house where a first lot would remain, with a setup so that a house that would be built here would front on a potential future street, a future extension of White Lake Road. In the meantime, we recognized and agreed that the new lot could share access with the first parcel, that it wouldn't be necessary at this time to put an actual half-street in the right-of-way, that for the time being, the street, the property could use the driveway of the first parcel, but we would be preserving the opportunity in the future to get a street connection there. And you'll hear from the original applicant, that can talk more about their perspective on that. They weren't initially really excited about the idea of a street connection. They weren't really interested or didn't think that it was necessarily a high priority for the city to get a street there as well, and also felt that the cost for them of building their share of that half street would be out of proportion with the impacts that they would have with their new development. And the city, in assessing that situation, came to agree that there was a great value to us to get the dedication of the right-of-way, and that when you did an analysis of the proportionality of impacts of the new lot to the value of the land being dedicated, that it wasn't necessary to push for any additional improvements. And so here's a view that maybe highlights a little bit what the proposal for a parcel 1, which has the existing house, and a parcel 2, which would be vacant and developed at some point in the future, with, at least on paper, dedication of right-of-way, both for a potential future connection of White Lake Road, as well as about 5 feet of right-of-way along 43rd, where the city is, I think, has a planned capital improvement project to build sidewalks here. So there is quite a bit of value to the city in obtaining this, the property for future right-of-way, even if, at least in this area here, for a future White Lake, we weren't getting any physical improvements. So that is what we worked out with the applicant and with our assessment of proportionality. So I guess some key points that I would make. One, just to be clear that the city did not initiate the concept of a White Lake connection. What we did was we worked with the applicant and responded to a particular proposal in this particular location, recognized an opportunity for a potential connection, and are trying to preserve that possibility. We didn't come into this proposal with any specific plan or timeline or funding to make a full-blown connection White Lake Road. We're simply working in this particular development context to get the right-of-way that will allow us some options in the future to make a connection. And those kinds of connections, like I said, in our transportation system plan and the code, they are a priority, as you know, with the work that we're trying to do across the city with the SAFE project, building sidewalks, improving connections both for pedestrians and bicycles, not just vehicles, that we recognize, again, this is one of those opportunities we did not want to miss and brew in the future. Also, to be clear, it seems from some of the comments that there may be a little bit of confusion about what is actually happening with the partition. The property that is being divided at 10244 Southeast 43rd, that is the only property that is contributing any land right now to a potential future connection. There's no other taking happening of any other property. It's simply the kind of dedication that we are getting with respect to this one property in this one development context. So we, as I said, there are no plans right now for any kind of extension or connection for the city to obtain any additional property, but I'll talk a little bit more about that in a moment. I think a key here, if I may go back just a couple slides, the property at 4446 Southeast White Lake Road is really the key to anything else happening in this area. If the current owner or any future owner of this property here decides they're perfectly happy with the dead-end street, with the house that's there, they have no interest in trying to create a second lot, we'll probably never come back to this issue. So, that's almost totally property owner dependent. And so I just want to stress that the city has no funding and no plan. Obviously, if we wanted to try to make a connection, we'd have to either buy the entire property or, demolish a portion of the house. It's just, there's a lot that would have to happen for us to get there. So I think it's important to emphasize that this property is kind of a key to anything else happening here. And If this property were to develop in the future, there's still a number of scenarios. One thing that would have to happen is the property here, sorry, I keep losing my mouse, the property at 4446 Southeast White Lake Road, it's not a candidate for flag lot development. There's no way to carve a flag lot from White Lake Road and have both lots have the frontage on a public street that they're supposed to have. So while one can look at the lot on 43rd that we were talking about with this original partition, and you could see where it's wide enough and has enough frontage on 43rd that if there weren't the chance of a street connection here, you could see, potentially just cutting it down the middle, both the lots would have frontage on a public street, et cetera. But this lot, the only way it's going to be able to redevelop is if it dedicates as well land to the public right-of-way so that two lots can have frontage on a public street. Then what physically might get developed, obviously someone would need to get access, some kind of a driveway or way to get vehicles to the fronts of those two new properties. And that's where we'd work with our engineering department to come up with some kind of design about what happens at the end of that property as it's dividing. In this case, and I'm going to try to feel Alex's eyes burning into my back here as I say these things, and if he feels the need to come up and correct me, I'll encourage him to do that from our engineering department. In this case, it seems a little more straightforward that someone trying to create two lots, we could probably justify getting both the right-of-way dedication and at least some physical improvements to get people, bicycles, vehicles to those lots. So something physical would happen if this property develops. But that might be all that happens for a long time, because what's happening with this partition is while we're getting the property, we don't have any money set aside right now to make something physical happen in front of our subject parcel here, off 43rd. So the city would have to decide it had money to then go ahead and finally put in some physical improvements to make a connection all the way through to White Lake. Even then, we'd still be talking about just a 20-foot width of right-of-way that we would have obtained through both of these partitions. We still wouldn't have any property to the north to make more of like a 40-foot wide right-of-way connection. I'm not saying 40-foot wide street. I'm just saying the right-of-way where you can put a street, sidewalks, curbs, landscaping. In that case, if the city decided for some reason that it was really important to have a full through connection to White Lake Road, then what we would have to do is we would have to work with both of these two property owners, and we would have to negotiate and buy the portion of property that we need. And part of what we did when we were looking at this was we noted that in this case, especially on this property, it's pretty clear that the existing structures on this site are not in the way of where we'd be looking for just the right-of-way. As you get onto this flag lot, that's the Appellant's property, it is clear that there's a little bit more of a question about how close would a line, the right-of-way line be. At the same time, it does appear that the house is set back, potentially just far enough back that we could obtain the property we needed for right-of-way. But I believe, and again, I'll defer to Alex, that we would have some flexibility in that case to decide if we needed a full 40 feet of right-of-way, how much property would we need from both of those? Maybe we could get away with 16 or 18 feet so that there's a little bit more space, but that's a long ways down the road. And I guess a general point is that this portion of property is already effectively serving, not as a street, but it's a driveway. It is serving to provide access to the house. So in some respects, we kind of have a little bit of the beginnings of a street. It just doesn't go through, and it's obviously just intended for this property. So all that to say that there are a number of different scenarios and progressions for us to get all the way to a full-blown 40-foot wide right-of-way that's developed to connect 43rd to White Lake. Now, don't get me wrong, I don't want to say that would never happen, but I'm just saying there would have to be a lot of things that would have to happen. The city would have to make a lot of commitments of money and energy to make that happen. That said, we think it's important to preserve the possibility of being able to make those connections in the future. So I just want to clarify, there's no takings of other property happening with this partition. But I think a lot of the people who are here who have some concern about it are correctly understanding the potential long-term picture. And I think that's probably what they'll want to talk about a little bit. So that would mean some changes. If we went as far in the future as getting some kind of connection through, that would obviously mean some changes to what is currently a dead-end street system, and that's, I'm sure, a concern to some folks. So with that, I just want to remind you the standard for review for this kind of unrestricted de novo hearing is identifying some kind of error that was in the original findings or conditions. The staff's opinion is that there isn't an error, that we followed the code and the direction of the city policy correctly in obtaining the right-of-way dedication that we did for the proposed partition. And our recommendation to you is that you uphold the original decision, deny the appeal request, and proceed with adopting the recommended findings and conditions. You have a number of options. They're not quite as straightforward as normally they are, so I'll try to quickly walk through. One is you can follow the staff recommendation, basically deny the appeal, uphold the original partition as it was approved by the planning director, which would include the dedication of right-of-way for White Lake. If you decide that you don't agree, in particular with, I think, the right-of-way dedication, you could approve or uphold the appeal. You would need to modify the findings to identify some kind of error. And if you were interested in allowing the original applicant the opportunity to continue with some kind of partition, there may be some variances that would be needed. You probably would need to check with the applicant to see if they were willing to extend the 120-day clock to allow some of that process to play out. And so basically you'd be looking for a way to say, we don't think we need right-of-way here, but sounds like there's interest in a partition, so let's make some findings to have that happen.
And we believe there are variances that would be required that weren't approved originally or weren't dealt with originally.
Right. A third option would be you could uphold the appeal and basically say, yeah, it sounds like especially if the applicant wasn't interested in continuing with the partition, just to basically deny the partition that was originally approved as well, and that would kind of end that land use, land division. And then a fourth option is there is time to continue the hearing. There may be a need, if, again, depending on the disposition of the applicant, to extend the 120-day clock as well. So with that, I'll ask if you have any questions about what I've presented.
May I?
Yes, let's start over here.
So did in terms of the decision to go with the dedicated right-of-way, was there any discretion in the city's decision to obtain that right-of-way, or was that mandated by the interpretation of code?
I think and Alex, can I have you come up to the table to keep me in bounds as well?
I was going to note that another complicating factor here is the minimum density requirement, and we have these maximum and minimums in the zoning ordinance. So with without the dedication, the applicant would need to provide the opportunity for 3 dwellings. So what the dedication did was reduce the remaining lot size, so it was only 2 primary dwellings that were required. I don't know if you want to add to that at all, but that was part of what drove the dedication, was that aspect of this.
I'm sorry, can you explain that a little bit more? Because they could divide it into 3 lots and still only build 2 houses, correct?
Well, when we're doing land division, you have to create lots in such a way that you show or you're demonstrating that you're going to meet the minimum and not exceed the maximum density. So if I have a really large property and the minimum density is 3 units, if I want to create 2 lots, I have to make sure that one of those lots is large enough for a duplex, because I'll get 2 units out of the duplex, 1 lot on the single-family house. I'm showing you I've got enough capacity for 3 units, but I may only end up building a single-family house on the duplex-sized lot. At least we're not creating units of land that are too small to meet the minimum density.
So the right-of-way then takes away amount of square footage of land that then allows them to get down to a 7,000 square foot lot instead of a 9,000 or a 10,000 square foot lot or something.
Well, it's not so much that the lot size, because I think the two lots that are proposed are still relatively large. They're at least 10,000 square feet, but the minimum density requirement with the right-of-way dedication went down from 3 to 2, which I think, and again, the applicants can speak a little bit more to this about their thinking, but it perhaps made it a little bit more comfortable with the vision that they had for the property for potentially developing a new single-family house and having enough space for ADUs, accessory dwelling units, on each lot. They might have been able to reconfigure the lot pattern to capture the existing single-family house on a smaller lot and have a larger lot that was large enough to show that you could get 2 units on it, even if they didn't end up doing that. But that isn't the direction that we ended up going when we were talking with them and working with them on this.
Isn't an ADU another dwelling unit?
It's physically is a unit where someone can dwell, but it's not a dwelling unit that, for the purposes of density. ADUs don't count against density. They're kind of an extra, and that's maybe another discussion you guys can have.
Yeah, that's another discussion.
Primary dwellings only.
I mean, I guess you can talk about how that would change. That would make their parent lot or the other one smaller, right? If they had the 3, they wouldn't be able to have a nice 2 even.
Can you say your name, please, Alex?
Sorry, Alex with City Milwaukee Engineering. If they did have the 3 dwelling unit minimum, then one lot would get smaller to make the larger duplex-sized lot.
Right. Yeah.
I started with a question, but maybe I'll rephrase it based on what I just heard, which is that we don't have an opportunity in this appeal hearing to revisit the configuration that came to during the initial application. We're not here to second guess the decision around acquiring the right-of-way or splitting the property. We're simply here to look for errors in the application.
I don't know if that's quite right.
Well, I mean, look back at the criteria, and it says that you need to find an error in the findings based on a fact or a matter of law. I might look to our attorney to explain. I understand the fact part. I'm not sure I understand the matter of law part, or if there is a distinction there. But it's the basically, I think it is a question of what is the error? Where is the error? It's not what I would prefer. It's there's got to be an error or something.
Well, and with that in mind, to understand your question one way, although it's a de novo hearing, which means you get to kind of look at everything from, as if it's new, you are evaluating the proposal of this particular lot configuration with the city's requirement of right-of-way dedication. I mean, it's not to say that the property couldn't maybe be configured in some other way, but I suppose what's been presented and originally approved was a particular configuration.
Okay.
So was there an error in approving that? I
Or
suppose?
really applying the law, what that matter of law relates to.
Right. The standard review is to, as Denny has said, is to find out, or to see if you can find, or one can be pointed out whether there's an error as a matter of fact or law. So the law part of it is, was the code applied correctly? Were the criteria, was a finding for each criteria in the decision legally valid under the code? Did you evaluate it the correct way?
Okay. Thank you.
So I'm interested in the connectivity and the connectivity policy. What other opportunities between the 2 through streets right there, on either side that, that exceed the minimum distance or the maximum distance for intersections? What other opportunities would there be to provide connectivity between
White Lake and 43rd.
Let me see if I understand what you mean. So you're saying
So the policy calls for connectivity. I just had it. 600-foot spacing on Collector Street. And so, what other opportunities, where else could there be a connection between these 2 streets?
Right. I guess when we look at 43rd Avenue is a collector street, and the standard you're referring to is that there's not supposed to be more than 600 feet between cross streets coming into the collector. And so from King Road to Rodessa, it's over 600 feet. The question is there any other place in this area where we could get another street connection that would help us meet that standard of providing?
Right.
And the way things are developed already, we didn't see another opportunity. This appeared to be a pretty obvious opportunity to make that connection and meet that standard.
There's one opportunity to satisfy this policy, basically, in this area.
That's what we identified, yes.
What is the spacing between those two, between King Road and Rhodesia?
I think the spacing is approximately 650 feet, so it's not much over the standard, but it is over the standard, just by a little bit.
And then there's another spacing requirement for establishing pedestrian connectivity. That's 300 feet in residential. And that's pretty close to where I think where White Lake will go through, correct?
Yeah, it's just a little under 300, 250 or something like that.
Thank you.
You over here?
So in that parcel 1, parcel 2, where is parcel 2's front door?
Okay, let me get to that.
My question is, I guess if it's addressed off of 43rd, then what happens when the road comes in? Shouldn't the front door then have to change?
Well, fair question. So if we create parcel 2 and the way it meets the requirement of providing at least 35 feet on a public street is by demonstrating that it's providing well over 35 feet on dedicated public right-of-way.
Oh, okay.
So this line would serve as its front property line, and the expectation would be that a new house built on this lot would basically face or front this White Lake Road right-of-way. In terms of addressing, I think there's some flexibility it's our building department, I think, that handles addressing. And my guess is that as long as this parcel was taking access from 43rd, that in the meantime of any kind of other physical way to get there through this right-of-way happening, the house would probably have an address off 43rd. I mean, that would be something up to our building department and the fire district, I guess, to decide what's the easiest way to find this place and know where it is. But it would basically front on this dedicated but unimproved right-of-way.
So the way that parcel 2, the way that the house would sit from the access point of 43rd would be that the garage would be on the 43rd side and that the front door then would have to be on the right-of-way side for ease of being able to drive in and out of there.
Right, I guess, I would, the detail I would make is that, we would expect to see a front door or main entrance facing the White Lake Road right-of-way. Someone could also, certainly, if they felt like it was going to function for a long time with access off 43rd, you could certainly put another main type of entrance facing 43rd, but we would at least expect or require one to be here. And then in terms of the garage, I suppose if what you mean is what would be easiest would be for me to just drive in through the shared driveway and go right into a garage on this face, yes. I mean, I could also design it so that in anticipation of a future improvement to White Lake Road, I could put the garage to face this right away as well. Obviously, I'd have to maneuver a lot more from where I'm taking access to do that. So I think the answer to your question is yes, we would make a front entrance face the White Lake Road right away. We would expect probably that if someone's going to have a garage, the garage would probably face 43rd just for ease of driving in there.
I believe the applicants thought about this some already.
Okay. Yeah. And then, so I want to make sure that I'm clear on this. The reason why you don't create White Lake Road from 43rd and make it a dead-end street so that parcel 2 can access and be addressed on White Lake Road is because of the detrimental cost to the homeowner?
Well, I think that probably the right way to answer that would be that when we look at the impact generated by the creation of a new lot, and we look at what the city is getting with the right-of-way dedication, the value of that property, we've kind of reached the maximum amount of value that we can get for that. It would be disproportionate for the city to say, you need to dedicate all that right-of-way, and you need to pay to physically build some kind of street.
Build a half-street then.
Right. So the city couldn't require that. If the applicant said, well, you know what, as long as I'm dedicating all this stuff, maybe I don't want to have parcel 1 be burdened with an easement providing access to parcel 2, I'm going to go ahead and just build a driveway through here so I can access it, because that way, parcel 2's got its own access, parcel 1's got its access, and I'm done. That would be another option, but not required.
The applicant expressed to us that they would prefer to keep the landscaping that exists today in that right-of-way and some of the structures. So, in the short term, without the need for that, we would provide an encroachment permit back to them for that.
And that other access, which is what I'm going to call the flag lot at 10194, right? I'm assuming that's a flag lot, that long driveway. And that cannot be an access point, irregardless in itself right to that second lot because of flag lot rules that you can only have one? Or is it because it's a property of 10194?
Well, what you're describing is another potential option if we create parcel 2 here. Let's say I buy parcel 2. I could approach this property owner, Mr. Barella, and say, hey, I'm interested in getting access through your driveway to my lot, and we would maybe try to come to an arrangement. Maybe I pay him something for a permanent access easement so I can get access to my lot. Maybe I want both. Maybe I get an access easement through here, and also I would like an access easement through here. Those are things I'd have to negotiate with those adjacent property owners, but they're another option.
But the new owner would need to negotiate.
Right.
It's not necessary.
And none of those negotiations or none of those options would change the right-of-way.
Wouldn't change our requirement.
If our objective is to preserve a future connection, it wouldn't have any impact on that.
Right.
Okay.
Right.
And then one more thing to note too is that there would be a minor change in that we would force for a shared driveway onto 43rd, which we're already getting with this partition. Both lots will be accessing through the one driveway. That is a requirement for new single-family lots on a collector or an arterial classification street. So we would not allow, the parent lot to keep their driveway and to have the other one have a second driveway. It would work to have it shared with the property to the north, but we would force a shared driveway.
You're saying I was wrong. You're saying that if the owner of parcel 2 wanted to build their own driveway through the right-of-way, we wouldn't let them do that?
Correct.
Okay. I'm stand corrected.
Okay. So there's only really one access point allowed. Well, there's 2, but one that only parcel 2 can control.
Correct. Yeah.
By rule.
Any other questions for staff? No? Okay. Thank you. Have we received any correspondence? Actually, before you get up, maybe you can talk us through correspondence on the matter other than the items included in the packet.
Yeah, so there was, the one item that was included in the packet was from the adjacent property owner at 4446, and that came in the same day that was the final day to appeal. I wasn't able to be in contact with the owner of the property to confirm whether, they didn't submit an appeal fee, so it wasn't a separate appeal. I took it and included it in the packet as basically a comment or opinion on that, on the original partition. Then we did receive on Monday a letter. I've got 3 extra copies if anyone in the audience wants to see one, from Leslie Schochner, who's an owner and resident at 4681 Southeast Locust Road. And those of you who are on the commission in the recent past, when there was a subdivision application on Locust Road where we talked about a connection extending Melody Lane, and there was a lot of discussion and debate about a right-of-way dedication to create a potential for another street connection and what it might mean for several of the adjacent properties. She participated in that hearing as well, and so that's some reference for her comments. But that's the only other correspondence we received.
Okay.
Can I ask one more question to staff, please? Can you give at least 2 examples of this right-of-way taking in this particular scenario that's happened in the last couple of years? Have you made a decision like this without it being appealed?
Well, I would think the Logos Road is the similar situation.
And so could you
Off
tell,
of Logos, on the backside of Logos is Melody Lane, and there have been dedications along Melody, unimproved roadway that needed some other segments completed for it to work. I think we're still waiting for a segment.
Yeah, I think that's a recent comparable example where,
And then there was the other one on Logos Road where there was a connection from, that's no, you're talking about Melody. I was thinking about
Mullen?
Mullen, not Melody. So, I mean, maybe if you want to zoom in on and point to a couple of those?
yeah, if we could just kind of see some
Yeah.
examples, just to say that this is,
But yeah, it's not unusual for us to be in this situation where we are looking for options for connectivity.
and this was splitting of lots that was a type 2 decision with the right-of-way, or was this,
Well, the last one required, on the Melody Lane one that these guys were referring to, and I mistakenly was thinking was Mullen, required a variance, so it came to the planning commission.
is that the one that we did the bicycle, was the
That's right.
bicycle path or something, right?
Yeah, part of what that one was conforming to was maximum length of a dead-end road as well. Melody was already right at the max length, so partially to allow for adjacent properties to develop, and also to allow for further extension of Melody, that you would need to have a connection through, so it wouldn't be just a dead end. It could have another dead end past where the existing dead end was, but with the construction of a street through, then you would have a shorter dead end for the new extension.
So, yeah, this is, so looking at Google Maps here, it doesn't show us necessarily the lot lines, but this is Melody Lane, and let me just take the image off for a second. Basically, this is showing the end of the right-of-way, even though Melody Lane was not improved all the way to the end of the right-of-way, the right-of-way did touch this lot. This is the lot that was subdividing. So the idea was to keep the existing house on one parcel and then have Melody Lane come through, leaving one developable lot to the north of the new Melody Lane extension and 2 lots here. So basically it was 1, 2, 3, 4 lots extending Melody Lane to the end of this property that was developing. And then the requirement that we got into was getting some right-of-way dedication down the side of this lot so that in the future, when this property, and you can see this 1, 2, 3, all 3 of these properties are very large, deep property that all have redevelopment potential. And so the idea is, how do we extend a street or extend the possibility of a connection so that these people in the future, if they want, can divide their property and benefit by redeveloping? And so our decision in this one was, I think we got 15 feet of right-of-way from the property that was subdividing, which meant that in the future, this property, if it redeveloped, would give us 25 feet down its side so that it could carve off some lots. And that's a part of what Ms. Schochner's letter is referring to. She's, I think, condensing a little bit the timing. That subdivision didn't require these people on the adjacent lot to lose any of their property. It would only be in the future, if they developed, that was kind of the pattern of the plan that was being outlined for them. So that's one example. And Denny, you're thinking of Mullen and?
And this one was a subdivision. It didn't come to you because of a variance. It came because it was a subdivision.
That's right.
Yeah. And I was thinking of Mullen, yeah.
So let's see, here off of King Road, we have Mullen. You can see over time, I'm not sure where specifically you're talking about, we have
Further through now.
we have gotten, there is a lot of right-of-way that hadn't been fully developed, and there was only maybe one, is this the one additional lot that was kind of preventing a little bit of a connection here, but this is us trying to make, eventually get a connection on Mullen Street, which would allow redevelopment of some of these larger lots as well.
And we've gotten some dedications on the north side.
Yeah, there's a lot more.
Yeah.
I don't know what So we had, we've already got dedication from this one, and this one. And there's houses. That's what the the houses are shown, but just the dedication is not shown. So this is the only lot that is not dedicated, and then there's also 2 houses building here right now as well. So we're close to getting it through.
So it's a similar sort of incremental approach. This one's happening in a more accelerated rate than I think we'll see on this current situation. Those are 2 recent ones.
Okay.
I get it, what are
They
your
take time. It's not a instant development.
Okay, thank you.
Thank you.
So now we move to comments from the applicant. If you could come forward, please. You have 15 minutes if you need it. Okay. And remember to please state your name and address for the record, please.
Hi. I'm Michelle DeRosa, and my husband and I, Tony, are the applicants, the original applicants for the minor partition of 10244 Southeast 43rd Avenue, which also is where we live. I want to thank you for your time, the Planning Commission, for considering this, and for my neighbor for actually bringing it to you. It sounds kind of odd, because I do want you to approve my partition, but I also want you to know a little more about the story of how we got here, how it is that we came to this capitulation. I would call it a capitulation, not a compromise. And it's still my professional opinion, as well as my opinion as a landowner, about what this is really about. As I understand it, the appeal is from our neighbor Dan, and I think it reflects a lot of the neighbors' concerns in that area, not just his, about the future extension of White Lake Road and what that would do, particularly to their end of the neighborhood, their quiet, dead-end, safe part of town. And for us, this result, our application included right-of-way dedication, because for 2 years we wrangled with the planning department, and that's about all we could do to develop our property as far as we could see, without having to take this to LUBA and perhaps further. So, as a context for my remarks, I just wanted to tell you a little bit about myself. I'm a small business owner in the city. I have a business license because I do most of my law firm work from home with my dog. That's where my paralegals come. It's where my records are. I have an office downtown, but that's where I work most of the time. I'm an avid dog walker. Dan and I share a fence, and our dogs don't like each other much. But I don't think that's what motivated his appeal. It's not right. And in addition to that, I wanted to just tell you what I do for a living a little bit, because I think my remarks are informed a great deal by that. I'm a real estate attorney, and when we first met with the city for our pre-app meeting in January of 2016, they didn't know that. So there was some, and I didn't tell them actually until I got their summary of that pre-app meeting, because I wanted to hear what they would have to say without knowing they were talking to an attorney that knew what it meant. My projects include, I do master plan communities all over the metro area in Wilsonville. I have 3 master plan communities that I'm helping to develop in the Hillsborough area right now that'll bring about 1,500 lots to bear. And I'm representing a client who's in the process of a master plan community in Clackamas County, and that'll bring several hundred condominium units into the community. I also have a number of clients who are affordable housing developers, and that includes Habitat of Oregon, Habitat of Portland Metro East, Proud Ground. I used to represent Home Forward. So I have a fair amount of experience and dedication to the idea of affordable housing. And to that end, when we bought this property, we were really hoping to utilize a cottage cluster to develop it. And I think as the consultants for your cottage cluster study, which we're involved in, have found, it really doesn't work. So this was sort of a second choice in the first instance, because my hope would be to condominiumize this property after we build single-family homes or unattached homes, a site condominium, so that they could share the lovely, what one of our neighbors called the heritage tree. That's what I usually call it too. It's probably the largest deciduous tree in the city. It also blooms in the spring. You should come see it. What I wanted to let you know is that we met initially, as I said, with the Planning Department in January of 2016. And at that point, we received a summary of that meeting that included not only this 20-foot right-of-way dedication, which at the meeting, I know Brett will disagree with me, but I have witnesses to this. We were told that the city had plans for our property, which took us completely by surprise. And then they described how they really would like to have White Lake Road as a connecting artery to 43rd. And they explained how they wanted that 20-foot right-of-way dedication as well as the 5-foot dedication that you saw in the picture across the front, which we've never disputed. And in addition to that, the city said that in order to do this minor partition into 2 lots, they would also require an 8-inch sewer main to be installed, a 6-inch water main, full sidewalks for the 232 feet, an engineered public road. So I had AKS, who were our consultants and our surveyors, spec that out, because I wanted to know how much that would cost. And in 2016 dollars, that they came to an amount of $187,000. And that did not include the value of our land. So that's what we were looking at initially. And this is much better. The city has, obviously, the planning department's made some considerable concessions since then, which are reflected in our application. But I still believe, as someone who's published and spoken a great deal about unconstitutional takings, that this amounts to an unconstitutional taking. That this is very similar to the situation in Dolan versus the city of Tigard, which is the controlling U.S. Supreme Court case, where the city there, in exchange for development that was not conditioned, just like ours, this is not a conditional use. This is not a subdivision. It's a minor partition. They said they wanted more pedestrian and bicycle connectivity. That was a policy of the city at the time. That was their lofty goal, and not a bad one, nor is this. And to achieve that goal, they asked the Dolans to give them, or they required the Dolans to give them in exchange for their entitlements, 10% of their land. This would result, this 20-foot dedication over 232 feet amounts to 18% of our land, which is considerable. And it's not about the dollar, the fair market value, although I have yet to see the city come up with an appraisal about that, and I certainly haven't had one done. That's not the point in this nuanced, and I'll admit, very complicated area of law. I don't believe that this is a lawful requirement. So why am I going along with it? Because it will cost me more to fight it than I might get out of it at the end. And as my neighbors are probably learning, the city at some point, if it really was committed to having this road extension, they could condemn our property. You could condemn the property and give us just compensation as you're required under the Constitution of Oregon and the U.S. Constitution. So in this case, Tony and I might fight this requirement and spend a few years doing that, and tens of thousands of dollars. I'm a real estate attorney, but I don't do Luba pills. They're expensive. The attorneys I consulted thought that we had a very good chance of winning, but would require, even my buddies, a $15,000 retainer just to start. So that's what you're looking at. And so this is a weary capitulation. This is not a citizen who thinks that this is the right thing to do or a lawful thing to do. And I wanted to also address a couple of the comments that were made, if I may. The density issue is a tricky one. Our land is almost 27,000 square feet, and when you do the math, it comes within, 100 square feet of this density requirement. It's very, very close. And so Denny's right. When we looked at this, for the third time together or something, we realized that to do the minor development that we had been considering, a couple of houses, another home and a couple of ADUs, given that the cottage cluster thing just doesn't work and isn't allowed in R7, we realized that this dedication would, in fact, pull us right under the density requirement that would allow us to have two homes. We did, however, have an alternate configuration that created a compound line. We did find a compound line that didn't violate the 10% rule, that would create a 14,000 square foot lot whereon, in the future, a duplex could be created, and the home that's already there, thereby we would meet that density requirement. When we talked about that at a year ago, our last pre-app approval, it just became apparent that the city at least the Public Works Department is very locked in about this exaction. I'm calling it a taking because I think it's unconstitutional. You might call it an exaction in exchange for this partition. But Tony and I went home and talked about it, and we really didn't feel like it was worth the fight and worth the money that it would require us to put up the fight. And it wasn't an ideal, frankly, it's not an ideal configuration for that property at all. Not unlike a lot of configurations that are driven in development, driven by, I think, a misguided and long needed improved Euclidean set of ordinances. And I know that the planners are the first to admit that some of these ordinances that they have to abide by, I know that, do result in unattractive and inefficient use of land. But so on the density issue, we did have another configuration that would work, but the city made it clear that it wasn't going to go easily for us if we tried it that way. So we submitted this right-of-way dedication on our partition application out of weariness, if nothing else. And I think it took nearly 2 years, and I don't mean to make this sound like it was the planner's fault for this being dragged out. It certainly wasn't. They've been absolutely professional, committed to being timely. Brett in particular, who's been our planner, has been very, I think professional and very dedicated to doing a really good job according to what he understood the city wants him to do and what their priorities are, and has always responded very quickly. The timing issue is just every time we'd come in, we'd go, gosh, now what do we do? And we're busy people, so it takes us a long time to make decisions. But it has been a long time coming. And I think the justification that I understood, aside from a policy, which, by the way, is not sufficient for an exaction of this size, just a policy, a dream, that's exactly what Dolan confronted with the city of Tigard. It's exactly what caught the Clackamas County in trouble, losing a court case about 15 years ago based on Dolan and Nolan. They wanted connectivity. So this is not new. It's been tried, and it's very dependent on the facts, obviously, but I think our facts align enough with that body of law that it shows that this is not a lawful requirement. That
You have
said,
about 2 more minutes.
That said, I'm going to ask you to approve our partition application. Preferably, however, I would obviously prefer if you approved it de novo, saying, you know what, you shouldn't be asking for that right of way right now. If you want it, you can condemn it. That means that you'd have to buy it from me. You'd have to pay pay me for it. The city's looking for this as an opportunity to take our land for free. I mean, let's be very clear. This is an opportunity, but it's an opportunity to get that land for a minor partition, not a subdivision, right? Not a zoning change, something that's not a conditional use, for free. And I think that's the sole motivation of the city in this case, that they want it for free. And that my neighbors are concerned because it's going to give the incentive to the city in the future to condemn their property, or with the case of Frank's property, to require that dedication as an exaction for the development of the property behind us. Thank you.
Thank you. Any questions for the applicant? No, thank you very much. Okay, so before we hear from the appellant, we will ask for testimony in support of the applicant. So I'm going to look through, and I don't know if we have any opposition. Okay. Somebody wants to ask a question. We're going to hold on that since we don't have any testimony indicating that they're in support of the application. So we'll move on to Mr. Barella, the applicant testimony. If you would come up, please, and state your name and address for the record, and then you also have 15 minutes as well.
Hello, my name is Daniel Barella. I live at 10194 Southeast 43rd Avenue, and well, I'm opposed to this. And actually, this is the first house that I bought, and it just kind of got up to middle class here, and now it sounds like you're going to somehow, one way or another, take my property, which is kind of weird. But as I talked to Brett over there about the road, the 20-foot, isn't there supposed to be like some sort of 10-foot easement? I mean, what you're talking about runs right up next to my garage. I mean, 0.00, right there. So, and I haven't got a clear definition of whether this is a road or a sidewalk. So doesn't the homeowner have to get some sort of loan or something to satisfy the city's needs to put in a sidewalk, or what is it, a road? So I'd just like to have a little clarification of what this is. And I work for TriMet. I'm a bus driver, and I'm right there at the front lines watching the expansion of the homeless. And I've noticed that wherever there's a opportunity, a crevice, or anything to put up a tent, they're there. So, I mean, if you look at the bike paths that you want to put up, just go to the bike paths that are already around and you'll see major homeless there. I mean, kind of, haven't you seen the news? So, I mean, I fell for them, but how would we have to deal with it? Would we have to evict them, or would that be the city's problem and the future problem, which we don't know when this is going to happen? So how would that be dealt with? So I mean, like I said, when you run that road right through my property, wouldn't you have to tear up my whole driveway again to make up to city code or whatever it is? So I just want to know what the fair market value, and has anybody looked at the loss of my property value? So just things that I'm concerned about, and apparently, like, you can just condemn my property, so I just kind of want to know what's going on. Like I said, it's the first time, I'm a first-time home buyer, and
Yeah.
I'm just confronted with all this, so, and you're taking all my privacy away. When you run that road right there, I mean, you're opening my property because it's right next to my house. And would that Now, my front door would be facing White Lake Road. Would that change my address? Or how would that be addressed? So just some minor concerns, if you can let me know what's up with that.
Okay.
So,
Okay. Does anyone have any questions?
Did you get Mr. Kelver's letter in response to your questions that addressed many of these same questions that you're expressing to us?
I don't think there was anything about, the changing of the dynamics of my property loss. And when we discussed it, it was just, we'll run right up to your house. And so what does that mean? Isn't there supposed to be like a 10-foot easement?
Well, there's exceptions when there's, extenuating circumstances, like an existing structure and a right-of-way dedication. But again, I mean, this was all spelled out in Mr. Kelver's letter. I don't remember when that was dated, but it was included in the information packet in response to these questions. And so I'm tempted to defer to staff and our legal support.
Answer the questions, yeah.
To answer those questions.
Do you guys want to take those questions now, or? Oh, no, you provide additional, follow the protocol here. So staff will provide additional comments and be sure to address your comments when they come back up here after we hear some additional testimony.
Okay. That's pretty much it.
Okay.
All right.
Thank you very much. So now, in this hearing process, we now have testimony in support of the appellant. So that would be folks that have marked in opposition, right? I mean, they're in opposition to the applicant, so they're in support of the appellant.
Probably. I mean, without seeing how they were all marked. Yeah.
Okay.
Totally.
So now I'm going to call folks up that have marked opposition on their testimony card, and we'll start with Michael Sims. And come on up, state your name and address, and then you have 3 minutes. So everybody that filled out cards has about 3 minutes, so we'll just be kind of watching the clock. So go ahead. Thank you.
Okay, my name is Michael Sims. I live at 4480 Southeast White Lake Road. Retired military, moving back to Oregon back in 2008, bought my house in 2010. One of the key things was the neighborhood. We had several dead-end streets, so it was a nice, quiet neighborhood. There were kids in the neighborhood. They could play. It was safe. It was quiet as it was peaceful. By putting in this White Lake extension, which I am opposed to, that would take care of creating, as what was stated, with the homeless and other problems that are created by putting either small roads or extending the road and all the traffic. The letter that was dated November 28, 2018, by Dana Stearns, my name was not on it because I was out of town at the time, so I was not able to put my name on it. I don't see the two instances where the planners mentioned where they had done this same type situation was not a one-block road turning into a four-block street. You have Rhodesia, you have King, and you have 46 of access in and out of the neighborhood. The ones that they were showing, there was a lot more coverage of streets versus turning a 3-block street into a 4-block street, which is now dead-ended at both ends. Again, to me, something that's not cost-effective versus putting in sidewalks, transportation, and other things in other parts of the city that would be much more, advantageous to all the residents. So that's really what I wanted to say.
Okay. Thank you. Any questions? No? Okay.
Thank you.
Thank you for your testimony. Chris Leone.
Hi all, Chris Leone, 4471 Southeast White Lake. Mostly I just wanted to be on the record with some of my neighbors to be in opposition to connection with of White Lake to 43rd Street. So mostly I leave it at that. As a linguistic anthropologist, I would point out that I'm hearing both for future planning, the conditional tense what would happen, this would happen. I've also heard some future tense, this will happen. So I think that in case we wonder about any confusion about that, language around this might play into it and also give us a sense of what really could be happening. I guess there's desire for clarity for all the neighbors.
Yeah.
Thank you for your help with that.
Thank you.
Thank you.
Lance Olander?
I'll pass.
Olander? Okay, thank you. Okay. Frank Fessold?
Good evening. My name is Frank Fosselt, 4446 Southeast White Lake Road. One of 4 properties at the end of White Lake Road. It's a dead-end road. I'm a first-time home buyer, and I bought it because it's the end of a dead-end road. I'd like to thank Tony and Michelle for being such good neighbors. They've reclaimed a large area of yard that was previously overrun with blackberries and at least 2 other invasive species. It's now a nice green space with lawn, fruit, and nut trees. To add, I am in favor of the development that they have proposed. To add 1 or even 2 homes with a private drive on this 2/3 of an acre will help with affordable housing. Add between $3,500 and $7,000+ in tax revenue, and still leave a large, safe, private green space for natural drainage, the environment, and the residents that live there. I am against any White Lake Road or path extension to increase accessibility. It is not needed. From my driveway at the west end of White Lake Road, it's less than 150 feet to the nearest corner, which would be 45th Street. It's 2 houses, corner to corner over to Rhodesia, which would then run directly to 43rd access. Or just 3 houses down White Lake Road to 46th for direct access to King Road. So access to or from our homes is quite easy. Also a very short walk to Safeway. The 1 short block zigzag between streets also means it's not a shortcut for traffic to skip the light at 43rd and King. It also serves to slow vehicles in our neighborhood, which is a very good thing, in that there's 3 families with 5 children, all under 5 years of age, on White Lake Road. To extend White Lake Road after taking property and reimbursing owners, we would end up with a street with sidewalks at our doorsteps and a great loss of security and safety for our neighborhood. We're a very short dead-end street at the west end of White Lake Road, serving 4 homes on our side, and a private drive/flag lot coming from 43rd, serving 2 homes. With straight streets, cars do go faster. Remember the children and safety. Green spaces allow for natural drainage instead of adding to storm drain runoff. And then there's the cost of the street, sidewalks, and loss of privacy and safety. I was born in and grew up in Portland, Selwood, West and East Moreland. I bought my first home, this one in Milwaukee, because it's not Portland or Multnomah County. I would hope and expect our tax dollars to be better spent than to even consider building a road or path that is not needed or wanted and could only decrease the safety in our neighborhood. Thank you.
Thank you. Any questions for Mr. Fessold? So you are the property owner that's referenced in the staff report as the property owner that will effectively determine when any further action on this issue will occur.
Or a future property owner, yes.
Yeah, okay. I just wanted to clarify that so that my colleagues understand
Yes,
that.
Tony and Michelle are my back property line.
Yep, okay. Great.
So, I would rather see a third house in this spot right here.
We're going to need, I'm sorry.
You're going to have
Sir, you have to speak into the
mention
microphone.
Yeah, sorry about that.
Okay.
Yep, we
Gotta
can
be on
get
the
you.
Yes, I'm sorry. Maybe I can take
But
it with
we
me.
saw it.
Yeah,
I would rather see a third house go on that property in that basic location, blocking any further expansion of White Lake Road. But again, they would have created, they still maintain a large green space for those properties.
yeah. Okay. Well, thank you very much for your
Thank
testimony. I
you.
appreciate you being here. Thank you. Okay. Norm Holzer?
Yeah.
Come on up.
Actually, I missed the boat. I meant to, sorry.
Yeah, it's okay.
My name's Norm Holzer. I live at 11959 Southeast Curly Drive, Milwaukee, 97222. Retired letter carrier. I spent about 35 years in the Milwaukee Oak Grove area, a total of 43 years. I know that area really well. And the one that I wanted to talk about, the 3316 Washington address, I'd still like to say a couple of things, even though I know you've approved it. Could I do that?
I don't think so because we've closed the public testimony portion on that part of the hearing. This is the vacation rental hearing. I'm so sorry about that.
Say one thing about this property.
Okay,
then, since
okay, yes, as long as you're here.
Because
Please do.
I know the area.
Thank you.
White Lake ends at about 48th. And what was just said by the gentleman who lives in the property right adjacent to the one in question, that's one of the virtues of living in Milwaukee. A lot of streets don't go through. And for that reason, in my case, Curly Drive is a 7-house cul-de-sac. And that means that even though we're close to Highway 224 and Lake Road, we don't have to deal with all kinds of fast-driving, irresponsible people because it's a dead end, it's a cul-de-sac. And that's the same with this area here. And I really don't understand a city that has limited resources trying to take from people that the city itself probably can't afford to take. And so I'll close with that.
Okay.
And I consider this an education. Thank you.
Thank you so much. Okay. I have Daniel, oh, sorry, that's the appellant. Okay. So I don't have any other in opposition. I have to ask a question, and I have neutral, so we'll go ahead and take the both of those now. We'll go ahead and do the neutral first. Ellen Campos?
My name is Ellen Campos, and I live at 45 Southeast White Lake, 4505 Southeast White Lake Road, which is at the corner of White Lake and 45th. I am not in this cluster of houses that is touching the area, but I am within catty corner to the area, and I guess my question is, I had several things. Mr. Faisal was very, very articulate and answered some of my questions. But one thing I was concerned about is the lack of knowledge. We just found out very, very recently that this was all going on. And because it does impact my side of White Lake Road, we did not find out any information in a timely way that we could have participated earlier. So I was hoping that if anything is decided, a new plan or a new opening, that the neighborhood would be more informed at a timely manner so that we could have participated earlier. I think that's my question. Is that going to happen? Are we just going to accidentally find out that there's this meeting or any of the meetings that we could have participated back in November even?
I will defer to staff and have staff respond to that question as to when and how people were noticed.
Yeah, it was a 300-foot.
300
Well, I'm
foot.
across the street, maybe
Right.
an extra 50 feet, and we didn't know anything about it.
And if it was taken to the neighborhood, the NDA, or anything like that, so we'll have, and staff can address these types of type 2 decisions and communication with
Because we
neighborhoods around that.
get a lot of traffic from people wanting to bypass that light, and they come through our little shortcut. And because it's a narrow street, it's a small street, the 46, White Lake, and then over to Rodessa, we get a lot of walkers and a lot of children and baby carriages, people who want to avoid 43rd Street comes through that area. Now, the traffic hasn't been bad. It is not a problem. But if that street went through, of course, to 43rd, it would be much more traffic and it would be a faster traffic. So that's my concern.
Okay. Well, thank you for your testimony, and we'll make sure staff address the communication. Thank you. And then William H. Schwint has a question for us. If you
have to come up.
Sorry. We maybe have, well, I know that Commissioner Hemer's wife watches this, so she can't hear you unless you're talking to the microphone.
All right. William Schwinn, 4468 White Lake Road. I had one question coming in and have had at least 25 of them answered that I never even had coming in. So I have nothing more to say.
Well, great. Thank you. We appreciate that. Okay, good. Well, we're sharing information, so that's very helpful. Okay, thank you all for that. And next in our process, we have the appellant has an opportunity for rebuttal and final remarks if you wish. And then the applicant can come back up and also do rebuttal and maybe address some of the questions. And then we have staff. So that's kind of the process. So if the appellant would like to come up and make additional comments, it's time for you now to do that. You're good? Okay, and then the applicant can come up and do rebuttal and make final remarks, and then we'll have staff.
Okay, this is Michelle DeRosa back again. Thank you for this time. I just wanted to clarify that the justification for this right-of-way dedication requirement, as we understood it, was not meeting the connector road requirement for an access way being a minimum of 300 feet from the next street coming in. As I understood it, that measurement was 307. So in my opinion, the reasonable thing to do would have been to give us a variance as opposed to taking 18% of our land instead. So I just wanted to point that out. If that's not the case, I'd love for staff to just to otherwise point to the ordinance that requires this dedication in this case, as opposed to just a policy and a desire and a dream for additional connectivity. I also wanted to address the fact that our property is part of the cottage cluster study, and we had spent already nearly $25,000 on this partition process and had our application just about ready to come in when we were invited to join that study. We're still part of it, excited to be part of that and to contribute to that. I'm hoping that the Planning Commission and the city will take that study really seriously and proceed with some of the modifications to the ordinances that are going to be recommended out of that. Our development could look really different if some of those things are adopted. But I do want to say that I want our partition approved, because if not, I'll have to reapply, which will cost me another $10,000 and require another delay in being able to go forward with our modest development. And one thing I also wanted to bring to your attention was a wish that when you look at those ordinance changes, one of the things that has impacted our property and our development plans is the linkage between getting an ADU permit and requiring street improvements. Those are actually linked. In my experience, ADUs are being built all over the metro area, all over the state, and with the legislation that was passed last year, became effective, a year ago, January 1st, 2018, requiring all residential zones to allow for ADUs. This linkage effectively blocks people from developing them because it's just expensive. We're looking at $20,000 to $30,000 of sidewalk improvements, even if all we were doing was permitting an ADU, which is a lot. So we know that we're going to have to do that when we go to get permits. If we were, we'll try to develop more than one ADU in order to make it cost effective. But if all you want to do is just put that accessory dwelling unit, linking it to street improvements is a really good way to quash that kind of affordable housing. So that's all I wanted to say.
Thank you. Any additional questions? No. Okay.
Thank you.
All right. Staff. Now, questions from commission to you, and hopefully you can address some of the questions that were also brought up.
Yeah, I'll say that there might have been a little confusion in the line out of the order.
Okay.
I think the way, for whatever it's worth, the way it was set up was staff comments and then hearing from the appellant and then the applicant and then questions to staff from the commission. So I guess I might just suggest that if anything I say in response prompts the appellant or the applicant to want to have some rebuttal, that you let them do that.
Okay, yes, thank you.
All right. So let me maybe work backwards a little bit from the question that Ms. Campos, if I have the name right, raised. I mean, she's correct that our standard procedure for providing public notice for type 2 and type 3 decisions is a 300-foot boundary. The line gets drawn somewhere, and there are always properties just on the other side of it. So I can appreciate that it may feel in this case like the ramifications of the decision are large enough to merit a greater notice period. I guess we followed the requirement for the distance, and it sounds like she wasn't on the list of who got notice. And then just an observation that, and again, I'll ask Alex maybe to keep me in bounds a little bit, which is her note about, and we heard, I think she wasn't the only person who talked about, there were a couple of mentions of people using those local streets to cut from King, miss the light at 43rd to get to 43rd. And I think it's probably arguable whether having an additional connection from White Lake Road to 43rd would increase the number of people who are cutting through. I mean, it's a fair observation. I guess I'm just saying if people are already doing that, providing additional street connection, I don't know that it's fair to say would necessarily increase traffic by itself. Sounds like people are doing it already. Mr. Leone's observation about language, and I guess a request for some clarity. There, I think, is by nature a lot of, and I don't recall exactly the terms he used for it, but there's kind of some conditional or language of would versus will. I think we're observing that we were dealing with this particular partition and the requirement that we felt was justified for right-of-way dedication as relates to this this application, we recognize that other property, that there are some other possibilities based on things that might happen. I mean, so I think it probably is best to couch the entire discussion in kind of a what if or would rather than what will absolutely happen, because I don't think there's any certainty about any of it. I mean, I think the certainty we can have is that there is no active plan or budget for this street connection. Beyond that, I think we're trying to outline what could or is likely to happen if certain other things happen. And so I'm not sure if that's really helpful to the folks who are wanting clarity. I think we tried to establish that the right-of-way dedication we're talking about was associated with this partition, that the Mr. Fasseld's property at 4446 Southeast White Lake was a kind of a linchpin, that while we can't say as staff for certainty what the city council may decide to do in terms of appropriating money, deciding that White Lake Road is suddenly a very important connection to 43rd, but our observation and experience of it is that we probably would not be dealing with any additional thing happening to make a connection possible unless there is a development proposed on Mr. Fasseld's property. So I guess that's maybe the best I can do with respect to trying to be clear about wills and woulds. I think we wanted to try to express that we do, my understanding is, and I'll ask the engineering department to correct me, is that there may be some flexibility if it came to actually trying to acquire the northern 20 feet that would affect Mr. Burrell's property and the other property adjacent to his, to the east, that there may be some options to take into consideration where, in particular, his existing house is and whether we would need to draw a new right-of-way line right next to his house, or whether there might be an opportunity to get a little bit less right-of-way so that there was a little bit more of a buffer there. And the same, well, I'll get to trying to address some of Mr. Barella's comments as well. So just with respect to clarity of language, I think that may be the best I can do. Regarding some of Mr. Barella's questions, he asked about a requirement for some kind of, I think he called it an easement, but as I understood it, he's meaning what happens if you do acquire some of my flagpole portion of property and you're basically shifting my property line. Let me see if I can get this to work. If we basically draw a new right-of-way line across the northern edge of his flag lot, right across here, it looks like it would be very close to his house. And as I understood part of his question, can you do that? What does that mean? How does the city code deal with what he understands to be a requirement for some kind of setback? And it is true that if this was the property boundary and we were seeing development of a new house, there would be a setback requirement. In the case where there is an existing structure, as Commissioner Edge pointed out, the code does allow for an exception. I guess when there is a dedication to the public right-of-way, a setback can be reduced for that purpose. Now, what we would want to avoid would be having the new right-of-way line encroach into his house. So that gets back at a little bit of the flexibility. So the code does have a way out of him having to meet that requirement. He wouldn't be doing anything actively to change it. It would be the city that's shifting the line with his right-of-way dedication or the acquisition of that property. So in terms of what kind of road would it be if we did actually acquire all that right-of-way and try to push something through, that hasn't been designed. We don't have any plans for that. There are a number of options, I guess, and Alex, I don't know if you can say what your experience has been with respect to design and engineering department. I don't know if an idea like an alley or something like that rather than a full-blown street is an example of something that might happen. If we might be talking about the possibility of you've heard the Woonaford, where it's kind of a shared facility where you expect to see people and bicycles and cars all in the street. The idea is it's low speed, it's designed somehow that way. That something like that might be an option. Another possibility might be just to have a bicycle and pedestrian connection. So, I mean, I think there's a number of possibilities, and we don't have a plan for it because there's no active plan to do that. Is there anything? Am I right or wrong in talking about the flexibility or?
No, yeah, you're definitely correct. There is a lot of flexibility in narrow right-of-ways and kind of what we're looking for. There's not an ideal. It's just that we want to make the opportunity for future connections possible at this point.
Mr. Burrell is correct. There hasn't been any assessment of the value of his property because we're not in any active process to try to condemn and acquire that property. That, as I understand it, that would be part of the process, would be the city kind of getting an appraisal or some assessment determining, or, a proposed value of the property. There would probably be a negotiation about it. I don't know how those things work exactly, but there is no figure for it because, again, there's no plan to acquire that property. And his question about how it might affect his address, I think I'd put that maybe kind of in a similar category of the question that we talked about with an address for Parcel 2, which for the time being would be taking access through Parcel 1 and would probably have an address of 43rd. If at some point in the future we did acquire right-of-way from Mr. Barella's property and he was now fronting on White Lake Road, we would probably work with him to change his address. I mean, that would seem to make sense, but I don't know. It seems like if we did put a street through there, for safety reasons, we'd probably want the address to reflect what the street designation is. So again, all that is, we're definitely talking about maybes and possibilities and way down the road on those things. And then finally, I guess I'll try to address Mr. Rosa, the applicant's questions or concerns about the properness or legality of the requirement, or I guess specifically she asked about us to point some direction to how we would deal with what kind of variance would be required or spacing requirements, that kind of thing. And I think if the partition did not involve providing this right-of-way dedication to establish the potential for a future street connection, then we'd be needing at least, I think, a variance from the standard requiring, or setting a maximum distance between intersections on a collector, as well as the pedestrian spacing requirement of 300 feet that Alex mentioned. So she's correct that however far over it might be, over under 307 feet, 650 feet, if it's just, a small number of feet, unfortunately, it would still be a type 3 variance. So I suppose when you get into your deliberations, you can think about if you were considering a variance request from those kinds of spacing standards for the reasons that have been articulated and your understanding of the code and the city's policies about connectivity, you would be then in a position to try to decide whether or not it was important to preserve the possibility for a connection there. So, yeah, I think.
So, those standards sort of point to a road pattern and a street system. And in fact, White Lake today points a dead-end street in this direction. So just that combination of things sort of set a pattern and a way of approaching this. So I think there's different ways to look at this. Ms. DeRosa certainly has her view. Our approach differed in terms of what was constitutional and what constituted a legal exaction as opposed to a taking. And we believe that we had the grounds to do that. And we certainly checked with our attorney at the time when we were doing this.
Yeah, I think that's
It was not our current attorney, but we checked with our attorneys.
Yeah.
They were involved.
Do you have anything else you'd want to say?
Yeah, so it's like Brett said right from the start, when we see a partition, we kind of zoom out and look at the neighboring streets. If there was no opportunity to extend any kind of street here, there is a different section of codes that we would be looking at. We wouldn't be looking at intersection spacing because they wouldn't be doing an intersection. There's all these different kind of a pathway that we would follow that a lot of the code would not apply. So the extension opportunity is kind of that path that we went down.
And there was another variance here that probably is in play, which is the minimum density requirement that we had to also consider. So it wasn't just a spacing issue, it was a density issue. So there were a number of factors that went into the approach to say a street connection here makes sense. And that's where we landed.
Okay.
So I don't know if you want to,
Yeah, I know. I really should get readers. Sorry, I missed that bullet.
We have an opportunity to ask staff questions.
Well, let's offer both the appellant and the applicant an opportunity to come up again. I'm sorry, I was out of order, but if there are additional comments that you would like to make after hearing staff talk, do you feel, or if you feel that staff adequately addressed your comments, you can feel free to come up if you want.
Hello again, Daniel Barella. I'm not too quite sure about, taking the property or condemning the property, but as a homeowner, I need to work on the house. So would it be obtuse to, put new windows and, redo my house? And then just to find out, well, you can't do that, we're going to take your property away? I mean, throwing a lot of money into the house to get it nice? Am I just a glorified renter that pays property taxes or what? I mean, kind of put everything on hold here, what I wanted to do. So it's just a major concern.
Yeah. Well, it sounds, staff is saying there's no plans, there's no money, there's no plans, there's no anything to take any action right now.
This is what I'm saying. I mean,
right.
So, would I be able to get permits? I wanted to add it on another garage. Would that be, you're going to put a road right through there and you're going to have to tear it down? So just everything's kind of stopped. With the neighbor's dogs, I've got a dog and I was about ready to put up a cedar fence, and now it's I got $600 worth of material ready to go up. And it's do I do that just to have it all ripped down? So
okay,
you're just kind of stopping me here on what I can do.
Right.
So
okay,
that's just a major concern.
Okay.
Thank you.
Thank you. And then the applicant, I'm sorry if you could come up again and.
It's okay. No, I appreciate it. Michelle DeRosa, the Constitution says that you can't take private property for public purpose without just compensation. So to Dan's point, if you wanted the road, the city wanted the road, it could condemn our property and pay for it, that just compensation. So I'm not afraid of improving my property for that purpose, even if, we went ahead and built a house that went into that 20-foot area, which would be our preference, actually. That's how you would fit a duplex back there, by the way. That's about the only way. I understand well that the city would need to offer all of the owners along that way just compensation. And if that meant having to take down Frank's entire house or his carport in his living room, then the city would need to pay Frank for that. If it meant taking down Dan's fence in his garage, the city would have to compensate him for that. So I'm saying that out loud because I don't hear anybody else saying that. And I don't want my neighbors to be afraid to do that kind of thing just because we want to develop our property in this way. Yeah. So that was one point. And the other, I wanted to just mention that while we're proceeding with this partition application, and we would like it approved, preferably without the right-of-way dedication as a requirement, we are also involved in this cottage cluster study, and the planning department has made it clear to us that if we were to pursue any other kind of development, i.e. not just a minor partition and a house and an ADU, if we were to pursue a cottage cluster of any size, that would exceed that one primary house in addition to this, or two, if we were to need that density, they would require not only the right-of-way dedication, but the $200,000 full Monty improvement, which I'm sure many of you have seen the pro formas that were developed by the consultants. That makes our property a lot more risky to develop because it by that $200,000 reduces the possible profit for an affordable housing developer. So the city, in my opinion, really needs to decide what's important. Where are your priorities? How much do you care about affordable housing? How much do you care about getting, we don't have plans on building a 3,000 square foot house back there. I have a personal dedication to providing affordable housing. That's what I would like to do. But I can't afford to do it. I don't know that any of my nonprofit developers could afford a $200,000 road to nowhere to city standards. You just, those kinds of projects don't pencil. I see them every day. My clients build them every day, and they cannot develop property where that kind of requirement for improvements is on the back of the developer. It just doesn't happen. It does not happen. When we have those kinds of developments in Wilsonville or in the city of Portland, it's more often that property is given to a nonprofit affordable housing developer. I'd love to sell my property to one of those folks. My clients would be very interested in having it. But when they find out that they're going to have to build a $200,000 driveway, effectively, they're going to say no. So that will mean that property is not good for that kind of development, even if we partition it and we wanted to sell just the back lot, and it would be eligible for a cottage cluster development. Putting in that $200,000 improved road is going to knock out that. It just, the bottom line will not work. And the city has to decide what's more important. So I hope that you'll consider the big picture, just like the planners have to take the 30,000-foot view. You need to take the 30,000-foot policy view. What's more important? What's more important? A big fancy driveway and taking that 20 feet? Or the potential of affordable housing on a property like this? I think it's a big deal. So I hope you'll consider that, even if you take a vote in 5 minutes and go one way or another. Thank you.
Thank you. Okay. Sorry about that misorder. Now we get to ask questions of staff, and then we'll close the public hearing. So I think we've got some questions. Brett, if you could come up. You were going to ask a question.
I do have one. When looking back at the similar example that you showed us on Locust Road, I recall that we were presented with a proportionality analysis that showed how the value of the right-of-way kind of factored into the city's decision. Was there any kind of quantitative proportionality analysis conducted on the value of the exaction, as the city's positioning it here?
For this partition?
Yeah.
Well, there was. The way that we originally wrote the notes, I think we decided in error, is the approach we took is basically writing saying the code allows for us to take all of these things or ask for all of these things. And that's where we kind of left it. The second time around, we said, the code says we can ask for all this. However, it's not proportional with only the addition of one new house. So therefore, we are not asking for the improvements. We're saying we understand there's a value to the land. Technically, you would be required to do some improvements. The trade-off we said was we understand the value of the land. No improvements are required. You can continue to use the land as you currently are. We're not making you build a new fence to separate it from everything else and treat it like a real right-of-way. It would allow it to effectively be your own, as it currently is kind of the balance that we struck.
So is the city required to do that proportionality analysis, or is that something that's discretionary for you to conduct?
I think rough proportionality is supposed to be part of the calculation.
It's listed in the code in Chapter 700 as one of the steps in doing the evaluation.
And so if we're, asked to find any errors of fact or law, the proportionality analysis seems like a place I would want to look to understand if there was an error in that exhibit. And so I'm just curious if that could have or should have been included in our packets, like it was on Logos, or if there was a conscious or unconscious decision to not present us with that information.
Yeah, I mean, I guess that would be one route to take with a challenge to this, would be looking at the proportionality.
Yeah, I don't think we got into the two specific numbers about appraising the property. I don't know that's a standard practice for us in rough proportionality. But, I mean, like Alex said, there's an understanding that there is some value to the land.
Yeah. Okay.
Okay. Any other questions?
Yeah, can I get clarification on, so can we deny the right-of-way without denying the application or the parcel split?
Yeah, I think what we had concluded was that if you can identify an error in the original findings or conditions, depending on what it is and how it might be resolved, it might be possible to come up with a different finding with respect to something like rough proportionality, where the partition itself meets, there's demonstration that it meets all the other required standards and or gets whatever variances it might need, for example, for density or spacing, and could then proceed with some approval just in a different form that is one that didn't have right-of-way dedication. So yeah, we're not exactly sure what the path is, but we believe there is a path.
But there would still be a burden of costs on the applicant to reapply for the variance, right?
Yes.
Okay.
And there would be some, assuming that the rough proportionality was somewhat accurate, there would be some other requirement.
Well, I'm just, if we can justify that the ROA is not needed, the right-of-way is not needed, then the question is that does the application get denied? And in essence, it does.
Well, no, I think we tried to line out, I don't think I was wrong in outlining your options, that one of them was to basically agree with the appeal. Oh, yeah, sorry.
Thank you.
I'm looking at number 2, that is basically uphold that part of the appeal, which is, challenging the right-of-way dedication, but finding a way to approve the partition without the right-of-way dedication, adjusting the findings, and maybe getting, including whatever variances are needed in order to support the approval of the partition without the right-of-way.
Are you saying that we would try to figure out those variances tonight?
I don't think we could figure that out tonight. No.
So then there would be an extra burden of cost to the applicant, because they would have to pay for their variance.
I think that we would probably need to charge for a variance application.
We would have charged for a variance application.
I understand that.
Right.
I understand that. But
right, so there'd be...
I mean, I can't recall. Were there any variances associated with the original?
No, I don't believe so.
Okay.
No.
Yeah.
Okay, I just wanted to be clear, because...
Yeah, I mean, there would be variances needed.
Okay.
And there might be some other rough proportionality conclusion that would involve some other improvement.
Or some other finding.
Yeah.
Well, there needs to be a rough proportionality assessment. I mean, that's supposed to be part of the thing. So the question is, what does that end up looking like? Yeah.
Okay.
And so would that be considered an extension of the hearing, and then there would be new evidence, so the rough proportionality would be...
Well, let's...
You're talking about a continuance?
If there is, well, I'm trying to think about how to structure it. Could you, I don't know. I absolutely don't know right now. Could we have a recess?
Yes, we'll conclude our questions for staff and then take a
and it might make
5-minute
sense
break.
to I don't know, you're not in deliberation yet, right? So we're still in Q&A, and we're asking a question about what would happen if you denied it, or
Ask for
It's
more.
what we have.
the appeal. Okay. So with that question, we will
All right.
try to explore what the options are.
Well, let's make sure there aren't any other questions here for staff, and then we'll take a little bit of a break. So anyone else with clarifying? No?
No, we need,
Okay.
that's the one.
That's the
That's the
rough
question we
proportionality
need to know.
is the, okay. Okay, so I guess with that, I'm going to go ahead and close the public hearing. No.
I
Do
know, I
not
keep
close
it
the public
open
hearing.
for when we come back
Okay.
and provide you with
Just take a
our
recess
answer.
without closing the hearing. So is 5 to 7 minutes enough time?
Yeah, probably.
Okay. We'll give you 7.
Could I ask one more question?
Oh, yes.
before we
Okay,
recess?
good. I was stalling to make sure that we get
sorry.
all the questions out.
In terms of the rough proportionality analysis and this looking for errors or facts of law, if we were to continue the hearing so that we could be presented with that information, would we be presented with an analysis that has already occurred and is documented, or would the city be allowed to use this time to go create a new analysis that doesn't exist? And how would that be considered in terms of an error in the initial application? Like, does the city have an opportunity to create new material based on these questions? and
Thanks, because that's
continuation?
actually what I was meaning with, that was the key question. I need to know that.
So does it
Do we get
exist?
what already exists, or would there be an opportunity for the city to create new material?
Well, as a de novo hearing, there's the opportunity for new testimony, new evidence. I mean, could that kind of information, based upon a request by the commission, be considered something kind of new that could be brought in to the discussion for the commission's final decision?
Let's take a break.
Okay.
Okay.
All right. 7 minutes.
So it seems to me that I don't.
And then okay, we're back from our recess. Thank you.
I think we need to have an understanding of what you guys were thinking with looking for additional rough proportionality analysis. As we looked at our rough proportionality findings, I think you could conclude that they didn't address this point, adequately, and that there could be error found just because we didn't provide that in the findings. So you could right today go, doesn't meet it, there's error. That's an option. The other option is, hey, staff, come back with the rough proportionality findings that support this dedication. That's another option. In speaking with Alex about that, it was a set of reductions that occurred in terms of moving back from kind of an ultimate build the whole thing to something that wasn't, it never ended up with actual dollar numbers. So there isn't, you can't just pull a piece of paper and say, here it is. So it would have to be sort of recreated for you. Where this all gets complicated is partly what the costs end up being for the applicant if we choose to reverse the process and pull the road out, because they then need to go back through a partitioning. They will need ultimately to resubmit a partition along with some variances. I think we could craft this so it's basically a continued partition and not a denial of the partition, but a continued partition, so that they could add the variances to it. In any case, on either of those, we probably need a continuance, like right away. We want to, because we don't know how to put all of that together yet. So my question was, were you seeking data in terms of support for the rough proportionality that would justify the road, or are you, if you were more inclined to move towards a decision that is looking to take away the road, and then we definitely need to hit pause. We need to hit pause either case, but then we need to hit pause and think about how to structure the decision. Does that make sense?
Can we go into a little bit of deliberation and then?
No, what I was going to suggest right now is that's my information to you, and I was going to suggest that you close the hearing, deliberate, and then continue this hearing to a date certain, a month out, in some form or another, which would be to look for additional support for the exaction, or to explore with the applicant options at this point for continuing the process to provide a partition and figure out what variances are needed and what the costs are to them.
Okay. Are there any additional questions for staff before we go into deliberation?
I might ask these guys if they wanted to add anything to that, because I don't. Okay.
Yeah, go ahead.
So are we getting an extension to the 120-day deadline?
Yeah, at least for 30 days.
Okay.
Well, when's the deadline up?
14th, March 14th.
Yeah. So we would come back in 30 days from now is what?
March 12th.
March 12th. So we're good for that, but we would probably want to extend it at that point, but we could have a better idea of how long we need to extend it.
Right, because this body's decision will be the final local decision, so if you came back March 12th.
And if we were going to take an approach where we're sort of hitting pause on this while we get the variance materials together and have the noticing for the variance and holding the partition open and having that partition revised to be consistent with the variance, that's what we would need the 120-day extension for. And I really don't know how long that's going to take, and it's partly up to the applicant about how they want to pull that information together. And they need to evaluate whether it's worth it to them to have that change and go through the engineering costs and everything else.
Okay. Anything else before we close the hearing?
So it's specifically the finding D on 19.705 rough proportionality.
Yeah, if you want to find error, I think you could just say that doesn't satisfy.
I mean, that's what we're focusing on, is this specific finding.
Yeah.
11D.
Right.
One way or the other, that probably needs to be supplemented.
Okay. I'm going to go ahead and close the public hearing for file AP-2019-001 and have some discussion by the commission.
So, I'll agree that we don't necessarily have enough information in front of us to gauge whether or not there was an error in finding 11D with respect to rough proportionality, because we don't actually have the numbers to show, what is being exacted and, what is the impact, of one additional dwelling on the transportation system and so on and so forth. And so, I'll acknowledge that we don't have data to, I guess I don't think that we have data to overturn the finding either, or to say that it is an error. I mean, that's ultimately what it comes down to, is we don't have the data to say that this was an error that was made, in terms of legality. So, in the absence of data, which I think that we certainly have the right and ability to ask for, continue, or, to get a continue, or to continue the hearing and to ask for that evidence to help facilitate a decision. I have a lot of concerns about missing the opportunity. I mean, basically defying policy, the policy of the city in terms of connectivity. And that is that's what we need to do, when we're looking ahead, in terms of what's the city growing into, and, the neighborhood hubs and all these other concepts that are coming up with our comp plan, process. Preserving and enhancing connectivity, in some form. I'm not saying it needs to be a 40-foot right-of-way with, a 30-foot, paved street and, everything. There's, at whatever point that the linchpin property becomes, a future owner, whatever, decides that it wants to develop, that's when this becomes, and so whatever our comp plan at that time, whatever our regulations at that time say, are acceptable cross sections for streets and, road widths and, how wide the right-of-way has to be. I mean, all of this stuff is going to be kind of up to the future comp plan that is not yet adopted, because it's unlikely that the linchpin property, on White Lake Road gets redeveloped before the comp plan gets adopted at this point. And so I think that, when this comes to pass, our new comp plan will be in effect, and we should have new regulations, and so we have opportunities to make sure that things are addressed, with that. And I mean, obviously, we've heard a lot of concerns about, what connectivity might mean for the neighbors, and that's not something that's going to come into play until out in the future. And our new comp plan will inform how that actually occurs and guide how that actually occurs. And so I'm hesitant to support turning over or overturning the policy in this case for connectivity. I mean, the distance, the intersection density in that area is not good. There's not enough intersections to support walkability the way that the neighborhood hubs concept needs for these things to work. And so I just don't. I think there's a strong policy reason why we would want to preserve this connectivity option and not have to, not bypass it. And so, but I'm also frustrated that, the applicant has lost the ability to develop a third house because of the right-of-way dedication. And that's another thing that I think our comp plan needs to really look at. And, and she raised a lot of good points about housing affordability and the impacts of these dedications and everything on housing affordability and our goals in that respect. And so this is the time, outside of this hearing, this is the time to be looking at those policies and how everything, shapes our ability to deliver affordable housing in meaningful quantities. But it does not have any impact on this review. And it does not have any impact on our existing, the approval criteria that are in place today. And so given what our approval criteria is now, I'm inclined to overturn or to deny the appeal and uphold the original decision. But I think that we do have, I don't think it would be inappropriate to request more data, continue the hearing, request more data to justify the rough proportionality, and we can revisit that in greater detail when we have data to either support finding it an error or finding that it is justified. At this point, I'd be tempted to defer to the legal analysis that was already done by the city to support the original decision. And I don't see evidence at this point that justifies upholding the appeal. So.
Okay.
I would dialogue more about this if anyone has any other questions, but so Commissioner Edge, what I feel is that your argument is that you want your cake and eat it too. So in other words, you talk about that you want to, in the future comp plan, that we need more connectivity to make the neighborhood hubs go, and that's what are going to be our future comp plan. But then at the same time, you say, oh, well, we're going to really address this affordable housing in our future comp plan, but it doesn't really necessarily address this. And so we do talk about all this woulda, coulda, shoulda, maybes, yes, nos. And so your argument is basically based on maybe yes, what's in the future. I would actually say that standard 5D has not been met because the public, 5D, because the public does not have interest in this connectivity. And if you want to say that our policy is connectivity based on the future of a comp plan, or would you say that the surrounding neighbors that came out here in groves is actually the public? My other question would be is that I'm not really so sure that standard 8F, that if you have a street that doesn't exist, how can you actually require right-of-way? And it's supposed to be based off of laid out plots that were there before, and we haven't seen any evidence of what the original grid or whatever that was supposed to be laid out. Now, my catch-22 is that the applicant who is standing here saying that this is about, and I agree, it is a very inexpensive way for the city to take land away from a public owner or from a private owner. But they are also sitting here asking for this application to be granted. So I'm in a catch-22. I don't know if the data is going to prove yes or no to me, but what I also don't want to do is I don't want to put a whole bunch of extra burden onto the applicant to have to go through a whole big old process again just to get this simple division taken care of. It seems that they kind of came up with a compromise, even though that they don't really like it. I understand that the neighbors are really concerned, but it's the should, would, could, maybe, yes, no. It's that whole scenario that is the basement of your argument that, you know, in all likelihood, it's never, ever, ever going to happen. In all likelihood, if it's never, ever going to happen, then why even bother with the right-of-way?
So the...
No.
Okay.
That's just my point. But we got to be able to prove it, right? And so the only way that I would say that, but I don't really want to deny the applicant their opportunity to divide their property. If it makes a difference to the other commissioners to get a status on 11D, then I would actually like to continue it so that the applicant doesn't have the burden of having to, so that we can figure out whatever the variance process is without having them have to go through all of this whole rigmarole again. That's just the way that I kind of look at this.
Yeah, in as much as the applicant has expressed a willingness to, you know, allow things to move closer to the 120-day clock and maybe beyond, you know, then I think that's fine. I mean, there's opportunities for further, you know, negotiation and agreements on how, you know, they could proceed with this. I mean, ultimately, it's the policy that's in place right now. I'm not looking ahead to a future comp plan policy about connectivity. The policy is already in place now about connectivity.
Yeah, but the neighborhood hubs aren't.
Well, right, but it doesn't matter. That doesn't matter. What matters is that there's a distance. There's a maximum distance between connections. You know, on this type of a street. You know, on this classification of a street, and you know, there's not compelling evidence at this point, absent some kind of a report that we can look at and say, look, we are on very shaky legal ground and this could be overturned at LUBA. I have not been presented with compelling evidence to overturn finding 11D.
But I would say that it can be overturned with 5D, but you and I would argue about what's good in the public interest.
Well, what's in the public interest is the adopted policies. I mean, that's what's in the public interest.
Really?
Yeah.
I think that the surrounding neighborhood is also in the public interest as well. And we can argue the semantics about it. That's why we have 7 of us here to be able to do that. But you understand what I mean. I mean, just because it's current policy, it doesn't necessarily mean that it is adopted entirely throughout the comp plan process. That says that we're always constantly going to improve connectivity. The argument is that you're only 50 feet away
from
43rd to Roswell or whatever that next street up is, right? If the standard is 600 feet. And so if it's 650 feet, you're only 50 feet away from that next connection point.
It seems unfortunate to me that there's not a variance for that. And I will just add that I feel like personally this has everything to do with housing affordability. This is exactly the kind of bureaucracy that affordable housing developers face every single day. I think it's a huge opportunity for the city to, I don't know if I want to say make a precedence, but I do want to say it's just an opportunity for the city to provide, kind of put their money where their mouth is when it comes to having the cottage cluster study, being able to provide additional housing for somebody who is very clearly an affordable housing advocate. And so I think this absolutely plays into the affordable housing priorities that the city has stated that they have. I think it's a good opportunity. I think we're not that far off, like Commissioner Hemer has said, from that 600-foot connection. And I think the 300-foot connection as well, if I might be mistaken on that, but I think there needs to be a little bit of leeway here. I think the city has a good opportunity here.
Well, leeway can go a few ways, because connectivity is, as a policy, is something you're aspiring to. You're utilizing geometry and calculations of density to come up with really what's a value. The value is people have more options and can get around safer, more conveniently, and it actually reduces a burden that a lot of autos on small streets sometimes incur. But we're not really, the thing is, when you said cake and eat it to Commissioner Ed's argument, I think it's more about, he's presenting just as you are, this is trade-offs talk. This is all about trade-offs. Policymaking is all about trade-offs. There is not going to be a perfect marriage between our connectivity goals and our affordable housing goals, but we usually find where the trade-offs balance to determine what we do agree upon as a convening body of when we have these instances and these cases, and what are we going to do to go forward with. And sometimes I would say not every case is an opportunity at all to be a basis, because there's so many wrinkles, but rather we have a common framework that we deliberate on to make decisions, so that there's some foundational, there are precedents, but the precedence is in what we're framing and what we're talking about. Because, a lot of what I heard here is I really feel for where people come from, thinking, well, this would be a huge encroachment of our neighborhood and livelihood. And then combine that with the property owner feel like, well, this constitutes what I recognize as taking, and it's onerous. But I hear a lot of things that make me feel like a failure as a planner. I'm a planner by profession, because, for me, there's a lot of evidence and there's a lot of data and a lot of good studies about the value of connectivity. There's a lot of studies about how there's a nexus between connectivity, safe access, sidewalks, and affordable housing, or what you could say is livability, really. Affordable housing does have some very specific tenets and specific values that I don't want to conflate with livability. But what I'm trying to say for us here is we need to recognize that we're really talking about trade-offs, and we're trying to also recognize the sensitivity of the property owner's case. We're supposed to speak to, if there is evidence, testimony, and argument that compels us that the decision has to be overturned. And I think I didn't get that, but what I did get was what Commissioner Hemer was getting at, is that we do have an opportunity, though, to continue the hearing and approach it from the variance angle. I think that's fair and good. But I just want us to be careful about what we're proclaiming of this as an opportunity for a basis for affordable housing policy, as well as how we're talking about our measure 5, what is it, 5D?
Yeah, the interest in the public.
The interest of the public, because, that's very much grounded in to me, this trade-off element. and that it's going to spin into us conferring angles on perspectives from one way or the other, where really it'd be better to try to have a more common framework when we're talking about that 30,000-foot policy stuff. But on the specifics of what we can do, I'm interested in the continuing hearing and the variance option.
Okay.
I think I'm looking at this. I appreciate the focus on the big picture trade-offs and the policy goals. I think that the decision that's in front of us is more narrow than that, which is what are the errors of fact or law that would uphold the appeal. And I find this to be a very unusual hearing that the applicant is asking us to approve it in face of her objections. The appellant is asking to deny it for a suite of reasons that we can't consider around the livability of the neighborhood. And so they've both kind of come with perspectives that are interesting and worthy of debate in this public and open forum, but that aren't within our decision-making authority. Within our decision-making authority is, are there any errors of fact or law that were identified in this process? And I'm looking at this rough proportionality analysis, and I do know that the city has provided us with dollar values for this analysis. The applicant has talked, 18% of the property does seem disproportionate to me when a flag lot would suffice with some minor variations that I think we're very likely to approve. So my recommendation and instinct is to approve the appeal with the finding that the rough proportionality analysis was incomplete and likely not proportional, but we don't have the information to evaluate that. So that is the error that I find. And I would go with option 2 rather than completely, let's see, with the findings modified to resolve an identified error or fact of law. Really going down the variance route where a flag lot would be adequate and would not trigger the rough proportionality issues that I'm seeing. And so if there's a way to move this forward with some sort of flag lot or other partition configuration that does not raise these proportionality issues, that's my preference.
So I
would
think,
continue to get there.
I think we're talking about combining 4 and 2 together to get to that answer.
I think that's right, and that feels right to me, to give some space for this to be identify what is the exact variances and to not have to start this process from the beginning. So I think continuing is the right thing to do, and that there is an error in this application.
Okay, I agree with the error. And that is what has been found. And so whether or not the data exists and it wasn't included, I mean, the fact is that this information has an error in it. And as I literally interpret that, that's what we've found, right?
Thank you.
And
I needed to hear that. I was looking for the evidentiary aspect, so.
that's the way, I mean, literally, we have found that there is an error in the materials.
I would agree, and I think that's probably all we needed to say.
Yeah, I know we talked around a little bit about that, but I just wanted to know that the Planning Commission acknowledged it's either evidentiary, or you heard something from testimony, or whatever the third.
I'm happy if I'm happy if we come back here with the variance and kind of a different look at this aspect.
We could return with findings. You don't need to make a final decision tonight. You could make a preliminary decision, and we could return with the findings that say there was error in the report, and that gives us a chance to kind of figure out how to craft the direction and how to keep the partition open yet allow for the applicant to come forward with variance material.
Okay. Are we satisfied?
So is that just, I'm looking for a
Robert
motion?
Robert hasn't gotten a chance to go yet.
Commissioner Massey, our new fellow commissioner.
Yeah, I guess my question is, how do you
Make sure you're talking into the mic.
Yeah, how
Thank
do you
you.
continue, how do you combine 2 and 4? I mean, 2 is a decision and
Well,
4 is a non-decision.
We're basically going to say that there is an error
And I agree with that.
of factor law, and that we're going to continue the hearing so that the planning department can give us that evidence that was the error. And at the same point in time, it will give time for the planning department and the applicant to discuss the other options that might be available,
Well,
without having to go
basically
through the whole hearing again.
What I think you're moving towards here is you could do a preliminary decision that directs staff to come back with the findings in support of the appeal, along with direction to reopen the partition application so that that application can be supplemented with a variance application. That
So
then
the
gives-
preliminary decision is to approve the appeal, is that what you're saying?
Correct.
Is it really a decision, or is it number 4 to start for tonight? It's a continuation with direction to staff to get us to 2, so that it's not a preliminary decision tonight. It's direction to staff, I think.
That's true.
Does that sound right?
Thank you. Good clarifying questions, Commissioner Massey.
Adding value already.
Yeah.
Thank you. All right, well, I'll entertain a motion if we're,
Motion to continue the hearing to a date certain of
March
March 12th.
March 12th, I think.
12th or 14th? Oh, 12th.
March 12th.
Yeah.
Motion to continue the hearing to a date certain of March 12th.
Second.
motion and a second. All those in favor?
Aye.
Opposed? All right, we'll continue the hearing on March 12th.
Thank you, Commissioners.
Thanks. That was really difficult. You guys did a good job.
Phew. Let me just, okay. I'm going to, yes.
Yeah.
Same back
Yes.
channel.
So,
Okay.
Thank you for coming.
Thank you, everyone. Okay. Please tell me we don't have work session items tonight.
but we do not.
Okay. All right. So then next on the agenda, Planning Department, other business and updates. And I guess before we go to that, I would finally like to welcome, a belated welcome to you.
Thank you.
Commissioner Massey joining us for his first hearing process tonight.
This is my fire here. Yeah.
Right into it. So can you tell us a little bit about yourself, or give us a brief overview of you and
sure.
Planning Commission?
I know it's getting late. So I've been a resident of Milwaukee about 3.5 years. I grew up in a small town, and I was drawn to Milwaukee's, sort of a sense of community, and I wanted to participate, and that's why I threw my hat in the ring to participate on the Planning Commission. I'm glad to do that. I was I had a previous life as a career Navy officer in the U.S. Navy, and I had a different job every couple of years, moved around a lot, including captain of a couple of ships. And then I joined corporate America for about 15 years as a industrial safety director, and I kind of still have my finger in that area. And so I'm glad to be here.
Great.
Awesome.
Yeah, thank you. Okay, I'll turn it over to you if you have other
I don't
business items or.
Else,
Okay.
Unless the Comp Plan Advisory Committee met last week, 2 weeks ago, I can't remember.
February
It's all a
4th.
blur. And we sort of had our first discussion about housing, and we looked at some of the structure of kind of how we were going to approach it, and trying to apply equity criteria to the process. And the proposal that we brought forward got flipped around a lot, and we are sort of not really totally changing the approach, but changing the approach a little bit. It's a matter of taking the tools that we will use in the policies, and the policies that would kind of provide direction about design and density, and evaluating those tools in terms of equity, livability, environmental impact, sustainability, those types of factors. So rather than have policies in the housing section about those factors that I just listed, they become the criteria for evaluating the housing policies. So that kind of changed the way we were approaching it. I think that was the big change. Joseph, is there anything else that
You guys decided to stick with that approach?
Yeah.
That was good, yeah. I was fond of that approach, so. I thought it was a really good discussion. I'm really encouraged. It's really been fun for me each time I've gone to a CPAC meeting. Because everyone's just so, it really feels like so many of the people are on the same page, and we're all trying to do, good things and are being innovative about it. And it's been a really fun process to participate in when I've had the chance. And so I'm glad to have been formally invited to the Housing Committee meeting next month. And so, I'm looking forward to that. And it's just really encouraging. It forebears very well, what will come from this process, and it is just really encouraging. So I'm looking forward to that. It was really just kind of an introductory meeting, just get introduced to the policies, and then how do we want to structure things, going forward, and I think.
We presented a matrix that had current policies and then some evaluation of those policies. But we didn't get into a real deep discussion about any particular policy.
Okay, and then just to be clear, so that the next CPAC, so the CPAC meetings are always the first Monday of the month, and then the Housing Committee meetings are the third Monday of each month. So are planning commissioners invited to attend the Housing Committee meetings as well? That's the open invitation to attend CPAC, as folks have.
Basically, we had better turnout from CPAC members for the housing session than we've had for the Block 2 elements. So we got plenty of people that are interested, but if you're interested in coming, you can participate.
Okay, all right, good. Okay, let's see. Any other updates or discussion items? That's pretty much.
Brett is not here. I was going to ask about because at the same time as the CPAC housing meeting was happening, the DLC meeting focused on the downtown design review. Process was going, and so I wasn't able to attend both.
Yeah, and next month, it's likely that the discussion about the downtown design guidelines will be abbreviated because there's going to be a preliminary discussion about the design of the Coho Point site and what some of the preliminary thinking is about that, to sort of run that by the DLC members and see where they're coming from. So I think that will be the number one item on the DLC agenda, and then whatever follow-up from the last meeting will occur. I didn't get a thorough briefing from Brett about what happened, so I can't update you.
And then what are the Block 3 sections that what are the policy sections that are in Block 3?
Public facilities, natural resources, urban design.
God, it's an awesome set.
They're meaty. Everything's meaty. There's no more fat. It's all meat. Yep.
Okay. Okay, so then forecast for future meetings. February 26th is a hearing, and we've already got materials about that, a big stack of materials that were sent to us. So that should be a big one.
I did not receive any because I have gone paperless. Thank you.
Right.
You got a big stack of PDFs.
Okay.
And hopefully the March 12th public hearing isn't, hopefully it's closer to the first one tonight than the second one.
Yeah.
tonight. Yeah.
Well, because we'll be
Yeah.
I think
on
so.
March 12th.
We'd
we'll
be primed, right?
Back up. So March 12th looks to be a busy night.
But I credit Planning
So-
Commission deliberation that gets us there to have a fast one on the
Yeah.
12th. Because you all really gave me a lot of good stuff. I needed that. This was a hard one.
It's a hard one, yeah.
It was.
Well, it's still hard. It's not over
You all
yet.
really helped me, I will tell you that.
All right, well,
Brett's lead on the Rusk Road Senior Living Facility, so, and I'm going to be in Illinois visiting Mom.
Wow, so Brett's going to be really busy working on the March 12th and on
I was
the,
thinking, oh, man.
And David runs the show while
Yeah,
that goes on?
David will be here.
Yeah.
okay. All right, well, I will entertain a motion to adjourn.
Motion to adjourn.
Second.
Who seconded?
Greg got it.
Thank you, staff.
Commissioner Massey.
Massey got his
Did a
for
lot.
a second.
Massey got
Okay.
it.
That
All
was
right.
hard.
All those in favor?
a day.
Aye.
Aye.
Opposed? Meeting adjourned.